You're going to see the got it button to stay on the stream. Okay, stay on Zoom while we stream. But have I identified all the parties and staff correctly on Zoom? Am I missing anyone who's connected with a party or commission staff? We have a couple people that I don't recognize, assuming they're members of the public. So I have to admit, I'm a little handicapped here today because of problem with my computer. So tip for everyone, if your router breaks at home, your modem, your router breaks at home, don't plug your computer in directly into your modem. It does all kinds of bad things. And if it's a work computer, you lose your computer. So now I'm using a loaner. So at least we got up and running at the right time. But if I'm kind of looking around here lost, it's because where I think things should be, they're not. So it's like we're pretty good to go here. So yes, I think we have everyone here we're expecting, and we can get started. So let's get on the record. Welcome everyone to docket 9818 CE 100, the application for a CPCN of Ursa Solar for the Langdon Mills Solar Electric Generation Facility. This is Michael Newmark, the Administrative Law Judge for the PSC, here for the party hearing session. We've done 2 public sessions and we've been collecting public comments online. And now it's the opportunity time for the parties and commission staff to offer evidence. So we'll be doing that at this time. So first of all, we want to get our appearances stated on the record. So we do have our service list from a while back. I think it's up to date. So let's just have parties and staff make their appearances. We'll just do it in alphabetical order here. So Clean, Wisconsin.
Good morning, Your Honor. Brett Cordy on behalf of Clean, Wisconsin.
Okay, Public Service Commission.
Good morning, Kara Kuntz, Assistant General Counsel on behalf of the Public Service Commission.
Okay, Renew.
Morning, Michael Vickerman with Renew Wisconsin.
And Lauren Tan.
I'm here, Your Honor.
Okay, perfect. Okay, and that's all the parties we have. Get rid of the list. I think we can probably ditch the notice as well. Oh, and just to note for the record, we will still accept public comments. Oh, it's Tuesday, May 23rd. We're continuing to accept comments. I may have misstated that at the public hearing. Didn't see that. Okay, so Tuesday, May 23rd, comments can still be filed through our website or by US mail. So just need to receive those comments by next Tuesday. Okay. It's unfortunate. All right. So show us our offered evidence list. Hang on just a minute. Something's not. There we go. This computer just might be a little slower than mine, what I'm used to. There we go. Okay, I'm gonna try to move. These things. Sorry about that. Okay, so we do have our offered evidence list. It was sent to parties, I think it was 2 days ago. It should be up to date with the errata. Any corrections to the list in terms of identifying the correct documents? Anyone have any?
Your Honor, could you just move down? I'm sorry, I'm looking for my copy here. Just making sure that all 8 of our witnesses are on the list, and I think they are.
Need page 2, okay.
Yes, thank you. Yes, we're fine with that.
All right. Anyone else, corrections and issues with the list? Okay, great. All right, so let's now discuss any comments that I made, if there are questions about those. Let's see if I can display that here. So we did have just some corrections. We kind of reviewed some of these before at the status conference or motion hearing. Any questions about those now?
Your Honor, I can give you a couple of clarifications. We are certainly fine with what I'll characterize as sort of the technical corrections, and we'll make those. You did have 2 notes on witness Graham and witness Jaworski, where we referenced exhibit Ursa Solar application R.
Yes.
And I'm not sure why we did that. So we will make that correction. That was a mistake. That was my only comment on the technical issues. As to some of the substantive questions, I believe, as you said, we answered some of these back on April 12th, specifically as to the JDA and the good neighbor agreements. I think we discussed that and resolved that then. Going on to the question that you had back on April 12th, seeking with the diagram you created, the number of megawatts near Ms. Tan's house.
Yes.
And we are going to offer that as a new exhibit today. So that's not going to come in through witness June. It's going to come in through witness Zahner. And I provided that yesterday to the parties and to the judge.
Okay, great. Thank you. I must have been offline at that point. I hadn't seen it yet. So let me just take a minute to find that.
It was sent at the same time that we sent our pre-hearing disclosures. As
Okay,
part of that.
it was attached. Okay, all right. So there's 2.
So it'll be Zahner too, and this is a different exhibit, Maroos 3.
Isn't that either? Just take a peek.
And Mr. Zahner will walk through this.
Okay, okay, great. Thanks.
Additionally, excuse me, you had a question on exhibit Ursa Solar June 7 as duplicative of exhibit Clean Wisconsin Matheson 17. They refer to the same document. I believe Clean Wisconsin's testimony came in about an hour before ours, and I debated whether we should coordinate with them. I ended up not doing that. And so we did provide the full document, whereas Clean Wisconsin, I think, more strictly followed the ALJ's guidelines and gave just the provisions they were citing to. My thinking in providing the full document was because we were citing to it and Clean Wisconsin was as well. It made more sense to put it in. in its entirety.
Okay.
So ours is the full analysis for focus energy, but if the court prefers, we can just give the cover page and then the specific pinpoint and modify that exhibit.
No, that's fine. As long as they're different. I just don't want to have a complete duplication. Okay, I see that. Yes.
And then for Dr. Loomis, you had a number of questions that you raised back in April, and Dr. Loomis is going to answer those questions, including the new one you added about reference to a professional manual in Wisconsin on appraisal.
Okay. Yeah, that was in the original version of this document. So I think that was provided during the last hearing, but that's fine.
Then I think the only other substantive question that you had was for witness Parrish on topsoil, and he's prepared to answer that with Ursa rebuttal.
Okay, perfect. So I know we did settle the issue of, or we addressed the issue of filing what we had called the sample JDA and any final agreement and sample good neighbor agreements as part of the appendix to the application. But I did have a question for, I guess it's witness, well, I don't know which witness is best one for this, but I did have a question about getting an update to those negotiations with the governments and good neighbor agreements.
We
Yes,
anticipated that, Your Honor. Witness June's going to talk about that in a Ursa.
Okay, perfect. Great. Thanks. All right. So
That was our only questions on the suggested edits.
all right, great. And other parties, Clean Wisconsin, any current questions? I don't think nothing I don't think changed for Clean.
No questions, Your Honor. As long as I don't need to do anything with Exhibit 17.
Yes,
Good.
that's correct.
Thank you.
Yeah, nothing changed for Ms. Tan, but we'll need, yeah, and she did file the revised direct. How about commission staff? Anything?
Nope, no questions.
And I'm sorry, I skipped skipped renew, sorry. In terms of renew, we did get those corrections. I don't think there's anything identified here. Yeah, I think they're all up to date. Okay, great. Let's clear this up a little bit. All right. Okay, well, if there's nothing further we need to deal with as a preliminary matter, let's have our first witness. So,
I do have a couple questions, Judge.
oh yeah, go ahead.
One is more a request, I guess. I am still caring for a newborn. Will it be possible to get a recess in a couple hours, like around the noon mark, so I can
Oh,
take care of some motherly duties, I guess?
yes, absolutely. We can definitely take a recess in a couple of hours.
Thank you.
I'll need that recess as well.
Um,
But let me address, and we'll see how long this takes, first of all. So hopefully may be the case that we can push through. But I did remember, now I'm recalling now, that some witnesses do have some timing issues. And you're gonna have to refresh my memory for that. I
I
think,
believe there was 2 that couldn't be seen till noon or after, if I read correctly.
Your Honor, Michael Marus, on behalf of the applicant, was flying this morning. We anticipate him being in front of a computer by around 11 o'clock today.
okay. And was it,
Yeah, Your Honor, our witness had something come up and is available at noon or later today.
okay. So I guess
And Your Honor, sorry, I requested to be taken before noon.
Okay, well, that's convenient, so, okay. So I guess the first thing we should check is, are there witnesses that there are no questions for? And I'm not sure if, I think maybe witness Tan or Lauren Tan is the only one prepared to ask questions at this point, is that? I guess we'll have some sir rebuttal too, some sir rebuttal, so let's keep that in mind. So we can keep going until at 11. We can take a break, or we can see where witness Marus is at that point. But yeah, so I just have to keep those things in mind. But I think we'll definitely be taking a break before noon, or at noon if we need to, and then we can see if those witnesses will be needed. We'll need to call them. We can do that now when they're available. So I think there's plenty to do before that. So, in case we get distracted with other witnesses, why don't we take a renew first and just have that one-time constraint eliminated from the mix. So let's call Michael Vickerman. All right, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. So you filed a revised direct, rebuttal, and Vickerman 1 and 2R, exhibits 1 and 2R. Are you familiar with those?
Yes, I am.
Are they complete and correct to the best of your knowledge?
Yes, they are.
Did you have any additional testimony to give as sir rebuttal?
I do not.
Okay, that's it. Any questions for Mr. Vickerman?
Nothing from the applicant.
Okay, Clean Wisconsin.
No, Your Honor.
Okay, and Lauren Tan.
Nothing.
Okay, commission staff.
Nothing.
All right, there you go. Thanks very much, and you're excused.
Thank you.
All right, so let's get back on our normal path here. I'll have the applicant call its witnesses.
Ursa Solar calls Ken Jaworski to the stand.
All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Do, Your Honor.
Okay. You're a little low on volume. If you could just, at least on mine, can people hear him okay?
He's low.
Okay,
Yeah, it's a little low.
so we can go off the record. If you can try just getting closer, sometimes that's the simplest way of fixing that problem.
Is this better?
Yes.
Can you hear Debbie?
I can hear good.
Okay,
Thank you.
all right. You're the most important one to think about here. So, all right. Okay, so I swear you in. Yes, so go ahead.
Mr. Jaworski, did you cause to be filed rebuttal testimony as well as 2 exhibits in this case?
Yes,
And if asked those same questions today, would you provide the same answers?
yes,
Do you have any modifications to your testimony or exhibits?
no,
Is the testimony and are the exhibits you caused to be filed true and accurate to the best of your knowledge and understanding?
yes,
Have you reviewed the sir rebuttal testimony of intervener Lauren Tan?
yes,
Do you agree with Ms. Tan's response to your rebuttal testimony located at pages 4 and 5 of her sir rebuttal testimony regarding whether the project is a permitted use in the town of Courtland's A1 Agricultural and Farmland Preservation District?
no. Ms. Tan ignores the portion of my rebuttal testimony where I explain the project is a permitted use because it, quote, is authorized to be located in a specific place under state or federal law that preempts the requirement of a special use permit for that use, end quote. The project siting is governed by Wisconsin's statute, section 196.491, which preempts local zoning ordinances. The project's location is authorized by a state statute that preempts local permitting ordinances. Therefore, it is a permitted use in the town of Courtland's A1 district.
On page 5 of her Surrey rebuttal testimony, Ms. Tan states that Wisconsin municipalities are not required by state law to update their comprehensive plans every 10 years. Is she correct?
No. Wisconsin statute section 66.1001 sub 2 sub I states that, quote, a comprehensive plan under this subsection shall be updated no less than once every 10 years. End quote. While I'm not an attorney, the word shall is typically associated with mandatory obligation and is not a suggestion, as Ms. Tan claims in her rebuttal.
Does this conclude your Surrey rebuttal testimony?
Yes.
The witness is available for cross.
All right, we'll go through our list. Clean Wisconsin,
No questions, Your Honor.
Lauren Tan.
I do have a couple questions.
Okay, go ahead.
Mr. Jaworski, did you consult with anyone at the township of Courtland when you reviewed their documents?
No.
Did you consult with anyone in the Springvale Township when you reviewed their documents?
No.
Did you speak with anyone regarding the comprehensive plan at Columbia County when you reviewed their documents?
No.
So you haven't gotten any local input on what the local zoning ordinances and comprehensive plans, what their intent is then, since you haven't reached out to anyone, is that correct?
I reviewed the documents based on how they're applicable to the application. So the written word within the ordinances and the comprehensive plans are valid as written. There was no need for further interpretation or comment with those authorities, since both the ordinances and the plans were as written and consistent with my interpretation.
Okay, thank you.
Okay, see, Renew Wisconsin, just give you a chance. Silence is fine. Okay.
No questions, Your Honor.
All right, and commission staff?
No questions.
All right, so thanks very much. So do we have any redirect?
No redirect, Your Honor.
Okay, all right, thanks, you're excused.
Ursa Solar calls Andrew Graham to the stand.
Right, raise your right hand. And do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Mr. Graham, did you cause to be filed direct and rebuttal testimony as well as 2 exhibits in this case?
Yes,
And if asked those same questions today, would you provide the same answers?
yes,
Do you have any modifications to your testimony or exhibits?
no,
Is the testimony and are the exhibits you caused to be filed true and accurate to the best of your knowledge and understanding?
yes,
Have you reviewed the surrebuttal testimony of intervener Lauren Tan?
yes,
On pages 3 and 4 of her surrebuttal testimony, Ms. Tan expresses concern that Ursa Solar has not identified the specific best management practices, or BMPs, that it will use for erosion and sediment control. Why has Ursa Solar not yet identified specific erosion and sediment control BMPs for the Langdon Mills Solar project?
as noted on page 2 of my rebuttal testimony, the information to determine specific best management practices is not available at this time. This is because the specific locations, make, and model of the PV equipment have not been finalized. Therefore, the detailed design required to design the BMPs throughout the project would have to be repeated during the detailed design phase, and the BMP types, sizes, and locations would likely change as a result. The proper timing for the design of the BMPs is during the detailed design phase, when the erosion control and stormwater management plan is submitted for permit under Wisconsin Admin Code NR 216. While specific BMPs cannot yet be identified, Ursa Solar expects to obtain Wisconsin Pollution Discharge Elimination System permit to manage erosion and runoff during its construction activities. Ursa Solar will implement certain erosion control measures pursuant to this permit. Further, as discussed in my rebuttal testimony, Ursa Solar will follow the Wisconsin Administrative Code in developing its final erosion control and stormwater management plan. While Ursa Solar cannot provide granular detail about specific BMPs for different array areas until the project site is finalized, it will implement industry standard applicable erosion and sediment control BMPs both during and after construction.
At page 4 of her rebuttal testimony, Ms. Tan claims that you made contradictory statements about the slopes on which tracker axes will be placed in primary array area 9. Is Ms. Tan correct?
No. In response to document request B4 in exhibit LT Tan 1, I referenced the specific part of area 9 where Ms. Tan requested comment on her slope calculation. I responded the trackers in that area of question, as identified by profile diagrams in my response, were sloped less than 6%. On page 5 of my rebuttal testimony, I stated that, quote, in primary area array 9, no tracker axes are placed on slopes greater than 7.66%, end quote. I was referring to all of the trackers in area 9, not just the specific segment of trackers within area 9 that I referenced in my discovery response. Therefore, my statements are not contradictory.
Does this conclude your sir rebuttal testimony?
Yes.
The witness is available for cross.
Okay, Clean Wisconsin,
No questions, Your Honor.
Lauren Tan.
I just have one question. Could you help me better understand what you just mentioned about parts of the trackers in area 9 versus your other statement regarding all of area 9?
Yes, in my response to the initial document request B4, the response highlighted specific trackers in the area where the slope calculation question was directed, not the entire area of area 9. And I provided cross sections of the trackers in that location, and of the trackers that were indicated on there, the maximum slope was less than 6%. And then in the follow-up, I stated in my rebuttal testimony, which was regarding specifically the question about the entirety of area 9. And in that case, the maximum tracker axis slope is 7.66%.
Okay, thank you.
Okay. Renew
No questions.
and commission staff.
No questions.
Okay. And any redirect?
No, Your Honor.
Okay, you're excused. Thanks.
Thank you.
Ursa Solar calls Jeff Parrish to the stand.
Okay, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? Oh, need to unmute. Could have told you that before because I could see it. Oh, well.
I do.
Nope, still didn't hear you. Let's try your microphone one more time.
I do. Not good.
That's better. Yes, thanks.
Okay.
Mr. Parrish, did you cause to be filed direct and rebuttal testimony as well as 5 exhibits in this case?
Yes.
And if asked those same questions today, would you provide the same answers?
Yes.
Do you have any modifications to your testimony or exhibits?
No.
Is the testimony and are the exhibits you caused to be filed true and accurate to the best of your knowledge and understanding?
Yes.
Have you reviewed the rebuttal testimony of Wisconsin Department of Natural Resources witness Jerry Rademacher?
Yes.
At page 2 of her rebuttal testimony, witness Rademacher argues that Ursa Solar should leave existing vegetative buffers in place and maximize their width in proximity to wetlands and waterways. But if disturbance to vegetative buffers cannot be avoided, then Ursa Solar should limit such disturbance to after the construction phase of the project when practicable. Do you have any comments on this testimony?
Yes. While Ursa Solar will attempt to leave all vegetative buffers in place where practicable, The project may require removal of certain vegetative buffers to accommodate construction traffic, prevent panel shading, and provide a safe workspace during construction. Witness Rademacher's suggestion that Ursa Solar maximize the width of vegetative buffers in proximity to wetlands and waterways is also unclear. But I do not understand this as a recommendation for an order point requiring Ursa Solar to install additional vegetative buffers. If Ursa Solar removes any portion of existing vegetative buffers around wetlands or waterways, it will use appropriate best management practices to prevent the movement of sediment into these water resources. Ursa Solar will restore areas where it removes vegetative buffers in part or entirely pursuant to the project's vegetation management plan. Ursa Solar has no objection to an order point that requires that during and after construction, existing vegetative buffers not be disturbed to the extent practicable. Ursa Solar will protect existing vegetative buffers wherever it will not impact the project. As noted on page 2 of my rebuttal testimony, the order point on the issue should read, quote, Ursa Solar shall leave existing vegetative buffers in place where practicable, end quote.
Have you reviewed the rebuttal testimony of intervener Lauren Tan?
Yes,
On page 10 of her rebuttal testimony, Ms. Tan states that the project footprint is 8,765 acres. Is that correct?
no. It is not clear how Ms. Tunn calculated 8,765 acres, and I will not speculate on her methods. However, as noted on page 4 of my direct testimony, there are approximately 1,235 acres on which the project will be sited, which includes the primary site, alternate site, battery energy storage system, and other operational facilities. As noted on page 4 of Han Ju-jun's direct testimony, the proposed primary site is located on approximately 957 acres of agricultural land, with approximately 34 additional acres allocated to the project's substation, battery energy storage system, and other ancillary infrastructure. This approximate 991 acres of land, which excludes the alternate site, is where the project will most likely be sited.
Please respond to the following question posed to you by the ALJ, what would cause topsoil to be removed from the project site?
Some real estate developers remove topsoil from development areas, such as roadways, other paved areas, or building footprints, and sell the removed materials. There are no plans to remove topsoil and export from the project area.
Does this conclude your rebuttal testimony?
Yes.
The witness is available for cross.
Any questions from Clean Wisconsin?
No, Your Honor.
Lauren Tom?
I do have some questions, Your Honor.
Okay, go ahead.
First, I'd like to address the footprint area that we were just talking about, Mr. Parrish. So you mentioned the footprint. My testimony mentions the total project area. Are those two the same thing? Are they meant to be taken as the same measurements?
There is a project study area. There is a project area that, as I've stated, was 1,235 acres that includes the primary site, alternate site, and ancillary structures. And then there's the 991 acres of land that includes the primary site, ancillary structures.
So why in the application then does it state there would be a mile buffer around the project area? Sorry.
There are certain maps that were required in the application and filing requirements to include a 1 acre buffer.
So that bears no relevance to the project then?
The project would not be sited within the buffer.
Okay. I have, if we could switch gears, I guess. I do have some questions about the glare study and the responses that you had to those. First of all, could you explain to me, you used two different heights for measuring of 3 feet and 16 feet. 3 feet from what point and 16 feet from what point exactly?
That's the like the minimum height of a panel and maximum height of a panel.
So when you're taking those calculations and you're looking at the information you get from the glare study, am I understanding right that the panel then that you're looking at is at 3 feet of height and then 6 feet, 16 feet of height?
Yes.
Okay, and then at what height at those points of reference are you using?
I don't understand your question.
So if we're looking at 3 feet from out in the field and you're measuring at a point like point A, and the array is point B is at 3 feet, what height is point A at when you're making those calculations? What is the angle there?
The glare is measured at observation points, and those were set at I believe 6 and 16 feet. I'd have to look back at the notes. And that's to estimate the height of a first floor and a second floor.
Okay, so you don't use any measurements for anything higher than that?
No.
Okay, so if there's 3 stories, you cannot say with any certainty what the glare would be like from that top level.
Structures having 3 floors were not modeled.
Okay. So, and just to be clear, 3 floors, an exposed basement, a first level, second level, that would be 3 levels of a building. Nothing like that was used for a model?
No.
Okay. When the glare study is done, does it take into account then the topography of the area? So the hillsides that the panels might be on versus where the observation point actually is?
Yes. It doesn't take into account the topography between.
Excuse me just a second. Is everything okay?
Off the
I'm
record.
sorry.
That's right. Let me know when you're ready.
I'm sorry. Please go ahead.
Okay, back on the record.
The
So
model
did you have-
doesn't, the model doesn't take into account the intervening topography.
Can you explain that for me?
As stated in direct testimony, as stated in the glare study, the model doesn't include topography that would be between the observation point and the modeled arrays that may block the glare.
Okay.
And in that regard, it's conservative.
Could we switch focus to the noise study? Have you done the field work for those studies in the past?
I have not.
Okay. Have you gone out to any site where you've done a study like this after construction's done and gotten readings?
Have I, or has TRC?
Do you have knowledge of one? Have you reviewed any?
I have not.
Okay, so you can't, are you able to tell me that what measurements you've given prior to construction and measurements that are taken after construction are fairly the same? Do you have any proof of that?
I personally do not. I'm sure TRC does, but I personally do not.
Okay. Could you explain to me, I took a look at your resume, what sort of courses you've taken about the human experience of sounds in a rural setting?
Objection, Your Honor, relevance.
Any response?
Well, I'm trying to get a better understanding of the expert and his knowledge base for the claims that he's making.
The study was done by.
Jeff, just wait a second, please. The ALJ has to rule on the objection.
Oh,
You-
sorry.
Did you have any further comment, Attorney Callisto?
Hey, Your Honor, he's already indicated he's not the author of the noise study. I think we provide that information in one of his exhibits. So he's sponsoring the exhibit. So I think he's expressed his breadth of knowledge on this already.
Well, but he continues to cite the noise study, so I'm trying to gather how he knows what he knows that has any different bearing on what my experiences would be.
Yeah, I'm going to overrule the objection. You can answer.
The noise-
Read back the question, or do you have? Let's read back.
The noise study was done by a group out of Boston that specializes in evaluating project noise. It's done by a group of engineers led by Michael Feinstein, and he has over 30 years of experience in evaluating noise.
Okay,
But
I can
you're-
repeat the question, because that wasn't the question.
Okay, yeah, go ahead and let's reread the question.
So what courses have you taken that about the human experience of sounds in rural settings?
I have not studied the human experience of sounds in rural areas.
And can you explain to me then, if I'm sitting here at my residence and there is what we're calling ambient noise, what the difference would be between that and when the inverter turns on? How will that experience change?
My understanding of the noise study is that it predicts a level of 31 decibels at your residence. And that is lower than the ambient noise level that's in a library, which is around 40 to 45 decibels, or dBA.
That's a great analogy, but it doesn't explain how hearing crickets outside or any other ambient noise, what the difference will be when the inverters turn on. That's what I'm asking.
Well, it was the conclusion of this. It was the conclusion of this study and communication with the noise experts from the TRC team that it would not be discernible at your residence.
So when they turn on, I will still be able to hear crickets and buzzes, bees buzzing, everything like that. I won't be able to hear the inverters from my residence.
That was what the model predicts. Yes.
And does the model take into account the topography of the area as well?
Yes, it does.
And are you aware that the observation point for the noise study isn't my residence? It's actually down the road and up the hill a little bit?
The observation point allows for a comparison of the infield measurements with modeled decibel levels at that point. There are predicted noise levels at your residence. There's a contour map of the dBA that does cover your location.
But the measurements given in the noise study do not show what exactly the changes would be at my residence. Is that correct?
Screen just blanked out on me. There is a tabulated comparison of ambient noise levels and modeled noise levels that's in the sound study. The noise levels that are predicted at your residence are presented on a contour map, but there isn't a specific sample point at your residence. For example, we didn't monitor the sound levels in your yard.
Okay, thank you. Can you tell me what would make the inverters, what sort of situation would make the inverters sound louder in one instance or softer in another?
I don't believe they would sound louder or softer.
So on like a snowy day when noise typically carries, that wouldn't be the case with the inverters?
Oh, you're talking about conditions. I thought you were talking about electronic conditions.
No,
Um,
environmental, atmospheric conditions.
Again, I'd have to talk to the folks out in Boston. I understand what you're saying. In winter times out, air is denser because of the temperature, and therefore it might might travel slightly differently.
So is there a possibility that that noise could be louder in those instances?
I doubt it.
The ambient noise that's calculated, do you know how they make those calculations?
The ambient noise isn't a calculation. Those are measurements made with microphones.
So it's just the sample from a few minutes of sitting here that they've taken.
They followed the Public Service Commission protocols for documenting ambient conditions. They monitored 7 locations in the morning, 7 locations at midday, 5 locations in the evening, and 3 at night. The Public Service Commission protocol for that also follows, or it was put together with guidance from American Society for Testing and Material Standard, ASTM, which is generally considered a gold standard for testing.
Thank you. I'm just trying to get a better understanding of how the studies work and what information I can actually take from them. So, Mr. Parrish, would I also be able to address with you the siting of arrays, or is that not part of your expertise in the docket?
That you can ask me. I'll answer what I can.
Yeah, and to the extent that you can answer, if you can indicate which witness can better answer that question, I appreciate that.
Okay.
So the inverters or the arrays placed in area 9 are on a hillside. Could you explain to me how those will actually sit? Like what heights will both ends be at of the posts?
I can't. That question would be better asked of Mr. Graham.
Mr. Graham or Mr. Zahner, probably, Your Honor. Mr. Zahner's coming up here.
Okay, well, if we can
Then
wait.
I'll save the rest of my questions for him. Thank you.
Okay, good. So all done with witness Parrish then?
Yes, thank you, Mr. Parrish.
And okay, any questions from Renew,
No, Your Honor.
Commission staff? Okay, I did have one follow-up from my question. I just wanted to point out what led to the question, and I don't know if it was directly addressed, and maybe it's just the way this was phrased. So it's page 8 on the Parish Direct. If I can find it now. Okay, so it's the line here on your currently on direct here. I'm just going to highlight that. Can you see that, witness Parrish?
Yes.
Okay, so the line was no topsoil is proposed to be removed from the project at this time. And so that led me to think, well, under what conditions would there be a possibility of topsoil being removed? From your answer today, it seems like there's no plan to remove topsoil. But I guess I just wanted to nail down that are there any conditions in which topsoil would be removed from the site?
Not that I'm aware of.
Okay. All right, so do we have any redirect?
Just briefly, Your Honor, Mr. Parrish, can you explain what the project study area is?
The project study area was 2,311 acres, and it was inclusive of the parcels that were participating in the project. And that includes not only the agricultural land on which the project will be sited, but it also included wetlands, waterways, water bodies, woodlots, other natural areas that were excluded to minimize impacts.
And is it fair to say that the project study area was the area that was evaluated by Ursa Solar for project impacts of the nature you just described?
Yes,
But the project itself will be on the smaller footprint as you described in your Sir rebuttal?
yes,
And on noise studies, Mr. Parrish, is it accurate that Ursa Solar will conduct a post-construction noise study?
yes, it is.
Thank you. No further questions.
All right. Just curious, is there a map in the application that just shows you project area? Just so we can nail that down visually.
The project study area?
Yes, project. So we have a general project area map. That's figure 4.1.4. I'm sorry, 4.1.1.
That's the study area.
That's the study area. Okay, great. So just maybe confusion with terminology, but that's the one we're looking for. Okay, thanks. All right, now you're excused. Thanks very much. Let's have our next witness.
Ursa Solar calls Hanju Jun to the stand.
All right, just a second here. All right, let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Mr. Jun, did you cause to be filed direct and rebuttal testimony as well as 7 exhibits in this case?
Yes.
And if asked those same questions today, would you provide the same answers?
Yes.
Do you have any modifications to your testimony or exhibits?
No.
Is the testimony and are the exhibits you caused to be filed true and accurate to the best of your knowledge and understanding?
Yes.
Have you reviewed the Sir rebuttal testimony of intervener Lauren Tan?
Yes.
Does Ursa Solar plan to reach out to Ms. Tan individually to discuss her concerns about the Langdon Mills solar project?
Yes. As I explained at page 14 and 15 of my rebuttal testimony and pages 3 and 4 of my third rebuttal testimony, Ursa Solar is willing to discuss potential solutions to Ms. Tan's reasonable concerns. However, Ms. Tan is currently a party in this contested case proceeding. Given her opposition to the project as a party in this proceeding, Ursa Solar believes it is more appropriate to discuss Ms. Tan's concern with her individually after the CPCN proceeding is complete. I will also note that Ursa Solar has directly addressed many of concerns raised in Ms. Tan's testimony with CPCN application material. The testimony of which expert witness response to discovery requests and other publicly available information. Ursa Solar has provided an immense amount of information about the project to the public.
Has Ursa Solar begun conversations with non-participating landowners about potential good neighbor agreements?
Yes. Meetings have been held with a number of project neighbors to discuss their concerns and the possibility of executing with them good neighbor agreements. At this point, there are no executed good neighbor agreements.
Please give an update on the status of the discussions on the joint development agreement.
Ursa Solar sent a draft JDA to the towns of Springvale and Courtland, as well as Columbia County, more than a year ago. There have been recent exchange of edits to the JDA to incorporate suggestions from the town of Courtland. I believe the town of Springvale and the town of Courtland would like to enter a JDA with Ursa Solar, and I'm optimistic that we can get there. At this point, it is unclear if Columbia County wants to enter into a JDA. I understand that their attorney has not responded to the most recent draft of the JDA sent to them by our attorney.
Is Ursa Solar aware of any landowners that are participating in this project that no longer want to participate?
No.
Does this conclude your sir rebuttal testimony?
Yes.
The witness is available for cross.
Any questions from Clean Wisconsin?
No, Your Honor.
Lauren Tan?
I have a couple questions, Your Honor.
Okay, go ahead.
Mr. Zhang, how many non-participating residents have you been in negotiations with for the good neighbor agreements?
At this point, it's 5 or 6.
And do you know how many non-participating residents are going to be offered a good neighbor agreement total?
Let me double check, but those 5 to 6 are only persons should show to discuss with our project. So that's the only number we have.
Okay, do you know how many non-participating residents are in the project area?
Yes.
And what's that number?
Let me double check. We have a list of non-participating landowner within a quarter-mile radius, so we can provide later.
Can you give us your best answer as you sit here today?
Let me check with our team and give you an answer before the end of this meeting.
Okay, thanks.
Your Honor, I'm sorry, I don't mean to interject here. Just to make sure we're clear on the record, I would prefer that Mr. June not reach out to his team during this hearing. So if there's information that we can provide, I have some redirect here that may help, but if there's information we can provide subsequent to this, we're happy to make an additional filing. I just want to be careful about reach out during the proceeding itself.
Okay, I understand that.
I will take an estimate of the number. I don't need the exact figure. I'll take an estimate.
Okay, well, do you need it for your next questions, or is it just information you're seeking?
Just information I'm seeking.
So let's get that number in as accurate as we can. If that requires a subsequent filing, that's fine. It's not something that's in the application though, or something that's already offered for the record, as far as we know.
Your Honor, I can address this on redirect.
Okay, all right, yeah, it's fine. Okay, so let's continue on. Lauren Tan, continue with your questions.
Mr. Zhang, are you and the team at Ursa going to be making the good neighbor agreements available to the public anytime soon, prior to the CPCN decision?
It depends on the negotiation, but we are try our best to execute a good neighbor agreement with the non-participating landowners.
So you're just going to do it on an individual basis? You won't be submitting it to the docket at all, or for anyone else to see it?
Each individual basis, each private agreement between the landowner and Ursa Solar. So if neighbor doesn't show any interest in good neighbor agreement, there's no reason to reach out to them to provide our good neighbor agreement.
In general, does the good neighbor agreement ask for like eminent domain rights or rights to use the property of the good neighbor who's signing?
Sorry, could you repeat again, please?
So in general, with the good neighbor agreements, is there any provision that states that Ursa would be allowed to use eminent domain to run wire or do something else on that particular individual's property?
No.
What was that?
No, we don't use their property.
There's not going to be anything in those agreements that would allow you to do any sort of development on their land or run any wires or anything like that?
No.
Okay. Can you tell me, and this might have been addressed already, how many acres total you have signed up for Ursa for this project?
Let me double check. As I recall, it was almost 2,000 something hundred acres, but let me double check with the exact number.
Would it be that 2,311 that was mentioned earlier, possibly?
That's what I recall, but I need to check the exact number.
And so let's just go with that number. I guess that's close enough for me if that's okay with everyone else. Because it's so that is significantly more land than you need for the footprint of the project. Is that correct?
Yes.
So would there be any large concerns about moving parcels of arrays? So certain array sections, since you have a significant amount of extra land for the project?
At this time, those 2,000 several hundred acres for development of this 200 megawatt project, we nailed down by additional environmental study and engineering works, and we excluded some areas not to use. So this, the final number of 957 acres that the land we are going to use. So this is optimal and optimal site plan for us.
But you do have other acreage available if you needed to move an array site.
At this time, other than 25 additional alternate sites, we don't have not much additional land to use for this project.
So then what's the purpose of having all the extra amount of acreage in the project?
To develop the project, there are many limited situations for the wetland or any other restriction. So to avoid those kind of restriction, we acquire the land, but we are not executed the lease agreement yet. We are going to only exercise the lease, the portion of we are going to use.
Okay, so there are other leases available that you could use if you absolutely had to move an array section.
Yes, we are going to exercise the lease as much as we are going to use.
I'm sorry, could you repeat that?
I mean, we are going to use the land as much as we are used for this project only. Other than those project area, we are not going to exercise the lease.
So I guess I'm confused. So you would or would not use that extra acreage if you needed to move arrays?
We would not use extra acreage for.
You will not. Is that slated for any other project?
Say again, please.
Are those extra acres slated for any other project?
Not this time.
Okay, that's all I have.
Okay, questions for Renew from Renew, sorry.
No questions.
And commission staff.
No questions.
Okay, thanks. All right, so I did want to, since we will
Your Honor,
yeah, oh,
I have
sorry.
some redirect.
Yeah,
that-
go ahead.
Thank
Said
you.
that so many times that I forgot.
No worries. Mr. June, can you please turn to page 11 of your rebuttal testimony? And the ALJ is pointed up for us here as well. And can you please read the sentence that begins on line 3, the first 2 sentences that begins on line 3.
Ursa Solar mailed the letter to non-participating landowner to leave that live adjacent to planned project infrastructure or with the project study area. 25 community members have received the letter.
And should that say, I'm sorry, that should say within instead of with? Within the project study area?
Yes.
With that correction, or is that list of 25 people the first set of individuals you reached out to in anticipation of having conversations about good neighbor agreements?
Yes.
You had a question from Ms. Tan about moving parcels to land controlled by Ursa Solar. Is it accurate that Ursa Solar is seeking approval from the commission to build the project on either the primary or alternate sites that have been provided as part of the CPCN application?
Yes.
Why did Ursa Solar pick the primary arrays as opposed to alternate arrays for the location it would prefer to build this project?
It is more efficient and optimal site plan for this project.
And was a factor as well the impact on non-participating neighbors?
Yes, we considered.
No further questions.
All right, so I think so. The way the record stands now, 25 letters were sent out to non-participating landowners. I think we probably still need to confirm what if the total amount is actually 25 or not. So, so I marked exhibit Young 8 for that information.
So, Your Honor, I just want to clarify for the record, you're asking for exactly what here?
Just the number of non-participating landowners, the total number.
We have sent letters out in various tranches. We've sent out hundreds, perhaps thousands of mailings to, as described in Mr. June's testimony.
Mhm.
So if the question is, you know, what was the reach out specific to potential good neighbor agreements?
Mhm.
I believe we just addressed that on the record.
Okay, because you just, okay.
Your Honor, the question was how many non-participating landowners will be getting an opportunity to review the good neighbor agreement or potentially sign one. Not how many in total there are, how many are going to be offered.
Okay, so we know, according to the testimony, that 25 community members have received the letter that was sent to non-participating landowners that live adjacent to planned project infrastructure or within the project study area. So does that answer your question, Witness Tan?
If those are the ones that are going to be reached out to for the good neighbor agreement, it does, but that doesn't specifically say that.
I believe I've addressed that on my redirect with them.
In what way?
We have
Maybe
a
I missed
readback,
it
Your
out.
Honor.
Yeah, let's have it read back. So if we can get back to the question, I believe that was asked of Witness Yoon regarding those lines of testimony.
I need a little bit more direction of what to look for.
Okay, so we're referencing Witness Yoon's page 11, line 3. I think that was said specifically by Attorney Callisto.
And it's just after he read that I asked him that I think.
Oh, it was after. Okay, so he read that sentence. 25 community members have received the letter.
And then it was questioned, and should that say,
right?
I'm sorry, should that say within within instead of within the project study area, answer yes.
Okay,
And
so
then
go
the
to the next
following
one.
question.
The next question, did you say?
Please. Yes,
Yeah.
please.
Okay. With that correction, is that list of 25 people the first set of individuals you reached out to in anticipation of having conversations about good neighbor agreements? Answer yes.
Yes.
Okay, is there anything else after that?
Are you asking me?
Yeah, yeah.
There's another question.
What's that question?
Oh, I'm sorry. You had a question from Ms. Tan about moving parcels to land controlled by
Yep.
Ursa Solar.
Okay, that's it. So the question was, is this the first set of letters? I guess we can just ask them, is that the total amount of letters? I don't, because I don't know what the problem with getting an answer for that is. But I guess we're wondering what the total amount of non-participating landowners that will be offered a good neighbor agreement, what that number is. And if it's 25, it's 25, but I don't think we've gotten that on the record.
I'm happy to ask him questions about that, Your Honor.
Okay, sure. Let's do that. So let's get back on the record.
Mr. June, do you have an exact amount of, strike that, do you have a number of good neighbor payment agreements that you believe you will offer at this point, or is that still to be decided?
It's only offered.
I'm sorry, say that again, please.
Yes, we are offered a good neighbor agreement to 25 people.
And have you had conversations with all 25 of them yet?
Not everyone.
And is that because some of them have not responded to the letter you sent?
Yes,
And when people have responded to the letter you sent, have you followed up with them and tried to get a meeting with them to discuss a good neighbor agreement?
yes.
No further questions.
Okay, yeah, that's, thank you for that. I think, I mean, maybe what we're looking for is, if the sentence read in this way, it says Ursa Solar mailed a letter to non-participating landowners. So that, we don't know how many letters were mailed in that, in terms of the first sentence, or is it 25?
Mr. June, you can qualify, is that 25 letters were sent out on using the criteria in the first sentence?
Yes.
And what criteria, other than what's in that first sentence, was used to pick the 25 recipients of that letter?
Yeah, we'll list up the most landowner who may impacted by this project.
Most impacted. So it's not all landowners that are adjacent to the planned project infrastructure.
Yes,
And it's not all landowners that are within the project study area.
no.
So, I guess in my opinion, I've always thought non-participating landowners were landowners that live adjacent to the planned project. And maybe that's a misconception of mine. Can anyone clarify that in terms of commission practice, what we've seen in other cases?
Your Honor, I mean, I'm not a witness, but
Yeah.
I think by referencing adjacent, they're trying to address the issue of who would be most benefited by a good neighbor agreement. So that's how the list was devised.
But it's not all landowners that are adjacent to the planned project infrastructure that were sent that letter.
If it will help, Your Honor, we will offer to bring an exhibit that shows the addresses of all of those against the map of the project.
Well, do we have a list of all landowners that are adjacent to the planned project area? I'm sorry, that are adjacent to the planned project infrastructure?
I believe that's the list that this was sent to. So maybe we're talking past
Well,
each
the
other.
witness just said no, because I asked him, is that all non-participating landowners that live adjacent to the planned project area? His answer was no.
Oh, sorry. We have a list of all non-participating landowners, and we will send this 25 letter who may most impacted by our project. So
Right,
we
most-
have all the list. Yes,
Okay, but most impacted is not all.
yes, you're correct.
Okay. So I think we should have a list of all non-participating landowners that live adjacent to the planned project infrastructure, and then indicate which one of those got, or which one of those is the 25 that sent a letter.
And how are you defining adjacent, Your Honor?
Well, adjacent, I think means abuts, is a bordering. I mean, I guess that's something I think we all understand. I don't know. Do I need to define adjacent?
Well, I think, why don't we offer to do this? I think what you're looking for is a list of who received the letter and a map of both those individuals against the project study area and any other occupied residences that we're aware of in the project study area.
Well, with the indicating who the owners are, I suppose. I mean, I think we have the mailing list. Don't we have landowners identified that are adjacent to the project area?
We do.
Okay. So why can't we have a list of those with the 25 indicated?
That's fine. If the 25 are a subset of that, as I assume they are,
Yes.
then we will track down a project mailing list of the relevant geography and then provide a list of who received it. Do you also want a map of that or no?
Sure. Let's put the map into.
Okay.
Okay, so I did have one more issue with the good neighbor agreement and the joint development agreements. I know we've discussed this before when I did ask for the applicant's submission of draft or I guess initial negotiation positions on that, and it is something that we have received in other cases. I'm sensitive to the applicants, the timing of this, and that they're still in negotiation. But I think getting the initial draft that they've already submitted to those counterparties, it would be valuable for the record, and they can be filed confidentially. That is completely appropriate, but I think I want to mark that. So I wanted to mark the list and map of non-participating landowners as June 8, and this and good neighbor agreement and JDA initial drafts as June 9. Like I said, that can be confidentially filed.
And Your Honor, to be clear on the JDA, you've asked for the initial version that was sent.
Yes, I believe that should suffice. If they're different between the towns and the county, then send the separate versions. But if they're the same, just indicate that they're all the same, that were sent to the three governments. All right. So any follow-up from all that? And let's off the record, Debbie, did you get those markings correct? 8 and 9, the exhibit markings?
Yes.
So 8 was the non-participating landowners, and 9 was the good neighbor agreement, JDA.
Yep.
Okay. So I'll be confused if you don't if you haven't written it down. So
Can we take a 2-minute break when we're done with this witness? Okay.
Sure. Yeah, we can do that. Sure. Okay. Anything else for this witness then? No. All right. let's do a recess. Let's take 9 minutes. So we'll be back at 11:30. How's that sound? Okay, all right. You can turn cameras and mics off if you want. It's 11:30, so like we're all back here. So we've completed our questions for witness June. And we can take the next witness.
Ursa Solar calls Lynn Wingers to the stand.
All right, I saw you there before. Raise your right hand and turn on your mic. Perfect. All right. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Perfect. Thanks.
Mr. Winger, did you cause to be filed rebuttal testimony in this case?
Yes.
And if asked the same questions, would you give the same answers today?
Yes.
Is your testimony true and accurate to the best of your knowledge and understanding?
Yes, it is.
The witness is available for cross.
Okay, any questions? Oh, sorry. Start with Clean, Wisconsin.
No questions, Your Honor.
And Lauren Tom,
No questions.
Renew. I don't see them there anymore. Okay, and commission staff. Don't see commission staff yet. Okay. Well, it's interesting. I guess at this time we are going to excuse you. Thanks very much.
Thank you.
Okay, next witness.
Ursa Solar calls Ryan Zahner to the stand.
Raise your right hand and do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
Mr. Zahner, did you cause to be filed direct and rebuttal testimony as well as one exhibit in this case?
Yes.
And if asked those same questions today, would you provide those same answers?
Yes.
Do you have any modifications to your testimony or exhibit?
No.
Is the testimony and exhibit you caused to be filed true and accurate to the best of your knowledge and understanding?
Yes.
Do you have an additional exhibit that you would like to introduce into the record today?
Yes. I would like to introduce exhibit Ursa Solar Zahner 2 into the record.
Please summarize this exhibit.
I am introducing this exhibit in response to a question posed by the ALJ at the April 12th hearing in this proceeding. The exhibit provides the generation capacity in megawatts DC of 3 separate solar panel layouts located in the primary array area 9. These layouts combine for 26.29 megawatts DC of generating capacity or generation capacity. I estimate that these 3 panel layouts will generate a total of 38,040,183 kilowatt hours of electricity during the project's first year of commercial operation. It's approximately 10.1% of the project's estimated yearly electric generation.
Is this additional exhibit that you have caused to be filed true and accurate to the best of your knowledge and understanding?
Yes.
Mr. Zahner, have you reviewed the surrebuttal testimony filed by Ms. Tan?
Yes.
And in her surrebuttal testimony, does Ms. Tan continue to have issue with claim project impacts on her and her property?
Yes. She states in her surrebuttal testimony that, quote, Ursa is shedding responsibility by waiting until after their application is approved when they are not required to make any changes to address Ms. Tone's concerns or that of any other non-participating landowners, end quote. She also states in her surrebuttal that the applicants, quote, have not been able to prove Ms. Tone will be able to enjoy the same quality of living she currently has, end quote.
And as a result of her continuing concerns about the project's impact on her and her property, has Ursa Solar evaluated moving solar panels from primary array area 9 to an alternate area?
Yes.
What is the most reasonable alternative location for panels in primary area 9 based on this evaluation?
Ursa Solar evaluated moving 13,248 panels in primary array 9, which are highlighted in green in the exhibit Ursa Solar Zahner 2, to alternate array area 16. Ursa Solar believes alternate array area 16 is the most reasonable alternative location for the 13,248 panels closest to Ms. Tone's residence for 2 reasons. First,
These panels have enough generation capacity to occupy 2 inverters. Alternate array area 16 can host panels with the capacity to occupy approximately 2 inverters. The panels in alternate array area 16 would also cover a similar amount of land to the panels moved from primary array area 9, meaning the swap would be reasonably similar from a capacity and land perspective. Second, primary array area 9 and alternate array area 16 are a similar distance from the project substation. As a result, electrical line losses from the 2 locations will be similar. After this move, the nearest project panel would be approximately 1,574 to 1,580 feet from Ms. Tone's residence.
Is primary array area 9 a better location for project infrastructure than alternate array area 16?
Yes. From an engineering perspective, keeping panels in primary array area 9 is favorable because the layout is contiguous with the other arrays, whereas alternate array 16 is isolated from other project infrastructure. Clustered arrays, as proposed in array area 9, increase the project's electric generation efficiency and make the project easier to construct and operate. The northern portion of alternate array area 16 also has some of the steepest slopes in the project area. Certain panels proposed in alternate array area 16 have their axis trackers on slopes near or above 63%, otherwise said as 10 degrees, which was a criterion Ursa Solar used to evaluate buildable areas. The slopes in alternate area 16 would not compromise the structural integrity of the panels, but they are unfavorable compared to the slopes in primary array area 9, which are no greater than 7.7%. Lastly, moving panels to alternate array area 16 is unfavorable from a community impact standpoint. A tenant-occupied resident is approximately 365 feet from where the nearest panels proposed in alternate array area 16.
Do you support moving panels from primary array area 9 to satisfy Ms. Tan's preferences?
No. Moving panels from primary array area 9 to alternate array area 16 would be unfavorable from an engineering and community impact standpoint, which is why Ursa Solar designed or designated array 16 as an alternate area. Moving panels to satisfy Ms. Tone's objections will place panels closer to a different resident than as originally proposed, and the resident may have similar concerns as Ms. Tone. Moving panels to satisfy Ms. Tone's preference would be at the expense of other residents in the project.
Does this conclude your rebuttal testimony?
Yes.
I offer this new exhibit into evidence and the witness is available for cross.
Okay, thank you for creating that. And I'll receive that exhibit. Are there any, well, if I really, let me hear if there are any objections, just in case. I did request this exhibit. Looks like what I requested. So any objections to receiving that? Okay. And I think I just wanted to clarify, you probably imagined I'd have a clarifying question or two. It might be useful to do that now, since before we continue. Where I don't see our witness on the screen here. I don't know what happened. There you are, witness Zahner. I have that your exhibit 2 on the screen here. And I just wanted to clarify, or maybe just if you just remind me, I think you did say this before, but in terms of the different array sections that are displayed on the exhibit, which are the ones that would be moving to would be moving according to the proposal to move them to alternative site 16?
So currently 3 of the array sections we have highlighted there, one in green, one in blue, and one in yellow. Those are all in the primary area called out as 9 currently. What we looked at was moving the panels in the area highlighted in green or circled in green there. Those are the panels. Miss Tone's residence is the residence there, kind of would be the northeast corner of those 2 road sections. So those are the panels and associated inverters closest to her residence. So the section in green, the 13,248 modules marked there is the section we considered moving to area 16, alternate area 16.
Okay, great. Just want to confirm that. Okay, perfect. All right. So any questions from Clean Wisconsin
No questions, Your Honor.
and Lauren Ton?
I do have a couple of questions.
Okay.
Mr. Zahner, could you explain to me how the panels will be sitting on the hill? If the hill sloping down, what are the post heights like from point A to point B going down a slope?
Typically, the trackers, the axis of the tracker, and you see the portion of the tracker that is kind of in alignment with the north-south direction, it follows the slope in general. So if you think of the piles that are embedded in the ground, what we would call the top of pile would be somewhere between 3 and 4 to 6 feet above grade. And that's the axis, and the axis itself would follow the typical slope.
So it would still be the same, like 3, 4, 6 feet above grade at the next point. Am I understanding that correct?
Correct. There will, as the detail of the topography, the ground isn't perfect, so there will always be some variance there, but there's a tolerance that we have to follow for the tracker manufacturer and the clearance for the panels when they rotate through the rotation. But in general, it's somewhere between 3 and 6 feet is the axis of that rotation.
If the hillside is sloping down, all of the arrays are sloping down that hillside.
Correct. Yes.
I know that you mentioned alternate area 16 and the residents located there. Is that a participating or non-participating landowner?
I'm not positive of that answer.
Okay. And was that the only site that those arrays could be moved to?
We considered looking at other areas as well. And when I looked at other areas, area 16, it is one of the alternate areas that has a size that's capable of accommodating a move like that, and it's the closest to the substation. And all the other areas that are alternate areas also have similar issues with residents close to them.
Like for instance, 19, I know there's a participating landowner that is the house that's cut out there. Since they're a part of the project, wouldn't it be fair to say that arrays moving to that point wouldn't cause any objections like they would for a non-participating landowner?
Objection, Your Honor. This assumes the accuracy of the fact in Ms. Tan's statement that there's a participating landowner somewhere near there. There's not a foundation for that at this point.
I can pull up the tax records and tell you what house is there and who lives there and what part of the project they're at.
I just want to have support, Your Honor, for that. That's my only question, because I don't
Okay.
know it as I sit here.
Well, let's lay foundation if possible. So, yeah, go ahead, Lauren Ton, if you'd like to give us the address and see if we can confirm that they're a participating landowner.
Yeah, let me grab it here for you.
And if you can explain, is that a document that's been offered in evidence in terms of the tax records?
According to the county land records, the address is W2712 County Road G, which is owned by Daryl and Marilyn Bubbles, who are a part of Bubbles Farms, which is a participating landowner in the project.
Okay, I'm not sure if we can get confirmation of that. Well, I think we can. I mean, that's certainly a possibility. I don't know how we're going to confirm that if the applicant has that knowledge offhand. If that person's landowner's participating landowner.
As I sit here, I don't know. I'm not trying to be
Right.
really difficult. I just don't know. As I sit here.
I
I believe
understand.
in the public hearing on Tuesday night, Daryl Bubbles spoke and stated he was participating in the project.
Well, we can certainly find that. You have the appearance slips here. Let's go off the record. And how easy this would be for you, Debbie, but you wouldn't. Oh, I have David Bubbles.
I can look that up.
Can
pretty
you?
quickly.
Yeah, that would be great. Okay, so court reporter is going to look at the public hearing transcript.
Your Honor, if it's any easier, I have no objection to Ms. Todd asking questions in a hypothetical way. If she wants to ask a hypothetical under the assumption that the house she's referring to is owned by a participating landowner, then we can go from there. Just to.
Yeah, that's fine. It would be good to have that though, if we can. It's not hard to do.
Okay, so I have his testimony up, but I'm not sure what I'm looking for. Give me a keyword or, oh, it's pretty short. Do you want me to just read it?
Well, does he indicate that he's participating landowner?
No.
No. Okay. All right.
I mean,
yeah.
Not in the words. He just
Doesn't
talked
say
to-
those words. Okay. Well, that's probably what we need to see to know for sure. So let's continue on with the hypothetical that the landowner adjacent to alternate array 19 is participating. So
back on the record.
Yeah, let's read back that last question.
Can you reread the question? I don't
Yeah,
remember exactly how I phrased it. I'm sorry.
That's fine. I'm looking for it.
Thank you.
Yeah, I'm sorry. When I asked her to read back the question, I guess I should have said read back the question. That's for the court reporter.
I'm pretty sure this is the question. Like, for instance, 19, I know there's a participating landowner that is the house that's cut out there since they're part of the, oh, sorry. I apologize.
Yep.
Wouldn't it be fair to say that arrays moving to that point wouldn't cause any objections like they would for a non-participating landowner?
Okay, so let's get back on the record. So I think the question is you, given the hypothetical that the landowner adjacent to array 19 is a participating landowner, I can't really phrase this exactly, but would this landowner be less likely to object to array 19 being utilized?
If you know.
That's fair.
Yeah, I would have no, I don't have any information on that topic.
Yeah, that's fine.
About how many acres would be needed to move in the map that you presented as evidence to move all 3 of those sections of arrays?
I don't have that number off the top of my head. And to compare one area acreage wise it's I don't want to say it's not straightforward or like for like, because the surrounding land conditions also have to be considered when it comes to slope, offsets, wetland, and buffer areas. So that's it gets a little tricky to do that comparison.
What would an approximate be with like let's say you have a flat field that you can place all of these in? What equivalent would that be for acreage that you would need?
I don't have that off the top of my head.
Do you know how much acreage or a comparable place that you'd be able to set, say, the arrays that are in the blue section?
No, I don't. Like I said, I'd have to dig into the data and pull those numbers out. There's enough variation between projects and project layouts that being that specific is difficult to answer in this case.
Let me ask a more general question then. The sections in green, blue, and yellow, with the alternate array sites that are given by the applicant, could all 3 of those colored sections be moved? Is there enough land to move all 3 of them?
I believe in general there would be enough land. You know, whether or not the specific conditions on those parcels would accommodate all those panels is difficult to tell at this time.
So they could be moved into multiple alternate array areas.
There's definitely a possibility that could be moved. An impact to, like I pointed out, there's definitely an impact to the production of the facility and potentially impact to other owners. It definitely moves panels closer to everybody else's house.
Okay, I guess I'm looking at several sections where there's larger swatches of land that could possibly be used. So it would be possible to move them if that's what the commission decides.
We could definitely look at it, yes.
That's all I have.
Okay. So I think Renew has left us, according to, I think that was true to what witness victimism was saying about his schedule. So let's move on. Commission staff, any questions?
No questions.
All right. Any redirect?
No, Your Honor.
Okay. All right. Thanks. You're excused.
Ursa Solar calls Dr. David Loomis to the stand.
Okay.
Who was speaking?
Yes.
Sal Peterson on behalf of Ursa
Oh,
Solar.
okay.
Thanks.
Mr.
Sorry.
Peterson's taking the next 2 witnesses.
Yes. Okay. Just
I knew
let
it
us know.
wasn't. I knew it wasn't your voice, but I couldn't see who was speaking. It wasn't lit up. Thank you.
Yeah, thanks. Just let us know next time when you're switching. No problem with doing that. Sorry. Computer here. Okay, Loomis. Okay, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Dr. Loomis, did you cause to be filed direct and rebuttal testimony as well as 2 exhibits in this case?
Yes.
And if asked those same questions today, would you provide the same answers?
Yes.
Do you have any modifications to your testimony or exhibits?
No.
Is the testimony and are the 2 exhibits you caused to be filed true and accurate to the best of your knowledge and understanding?
Yes.
Dr. Loomis, I'm going to ask you a few questions that the ALJ raised at the April 12th hearing in this proceeding, which are in response to your testimony and exhibits. First, were there differences between the economic impact study that you performed for the Langdon Mills Solar Project, provided as Appendix R to Ursa Solar's CPCN application, against the similar study you performed for the High Noon Solar Project?
Yes, my analysis shows differences between the two projects in the following categories: job creation, local earnings during construction and operation, new local output during construction and operation, and utility shared revenue payments to local governments. Additionally, my analysis shows differences between the two projects in the necessary increase in the price of corn and soybeans for the land and the project area to generate more income for the landowner and local community with agriculture than with a solar lease.
Can you summarize those differences?
As compared to the Langdon Mills Solar Project, my analysis concluded that the High Noon Solar Project will create more jobs, result in more local earnings and new local output, create more utility shared revenue payments to local governments, and greater increases in the price of corn and soybean to match the income benefits of its solar leases.
Please explain the reasons for these differences.
These differences exist because the High Noon Solar Project is 300 megawatts, larger than the 200 megawatt Langdon Mills Solar Project, and therefore requires a greater capital expenditure. The anticipated capital expenditure for the High Noon Solar Project is $372 million, as compared to $224 million for the Langdon Mills Solar Project. Higher capital expenditure leads to more dollars recirculating throughout the county and the state, all other things equal. The local economic benefits increase as larger purchases are made within the county and state. In addition, company-specific practices regarding local purchases of resources will also make a difference in the economic impact of a project. My economic impact study for the Langdon Mills Solar Project also did not contemplate the addition of a 50 megawatt battery energy storage system, or BESS, which is now proposed for the project.
How would the results of your study change if it included the 50 megawatt BESS now proposed for Langdon Mills Solar?
Because the BESS requires additional capital expenditure, it would increase the project's economic benefits in my analysis. However, it's impossible for me to say the exact increase in economic benefits without additional modeling.
In past solar CPCN dockets in which you've offered testimony and an economic impact study, you have not provided an opinion on a project's property value impacts. What makes you qualified to do so in this case?
I have supervised graduate research projects on hedonic price econometric modeling of real estate values and their proximity to renewable energy projects. Hedonic price modeling seeks to statistically determine the price of a house as a function of its set of characteristics. For example, the model would break apart the price of a house into the value of each bedroom, each bathroom, total square foot, and all the other aspects of the home that are relevant to its price. I am familiar with this approach in the economics literature and am qualified to comment on existing literature in this area. As an academic for 26 years, I have served as a referee for several journals, making recommendations on articles seeking to be published. Ursa Solar witness Michael Morose is a certified appraiser and can perform matched pair analysis, which is a different approach from the hedonic price econometric approach.
how does the addition of a 50 megawatt BESS affect your testimony with respect to the property value impacts of the project on surrounding residences and farmland?
I'm not aware of any existing literature on the impacts of a BESS on local property values. Therefore, it does not affect my testimony on the project's property value impacts.
Have you ever investigated the economic impact of converting land used to produce plant-derived energy, such as ethanol, to land used to produce solar energy, like the project?
No. However, assuming corn and soybeans are grown on the agricultural land leased for the project, the end use of these crops would not affect the results of my economic impact study.
Please respond to the ALJ's request for clarification regarding Exhibit Ursa Solar Loomis 2 and whether a professional manual exists in Wisconsin that contains guidance on home appraisals near utility scale solar.
Yes, on page 20 of Exhibit Ursa Solar Loomis 2, the authors state 2 respondents indicated that their professional manual or other training materials provide instructions regarding residential assessments near utility scale solar installations. These respondents were located in North Carolina and Wisconsin. I don't have any more information on whether such a professional manual exists in Wisconsin.
Does this conclude your Sir rebuttal testimony?
Yes.
The witness is available for cross-examination.
I'm just going to jump in with a clarifying question based on questions that were just asked. And Witness Loomis, you mentioned that one of the economic benefits to the local economy would be the use or the generation of local purchases and local employment. Is that correct?
Correct.
And I'm just curious, and you mentioned that as being local requirements for those things?
No, more I was referring to company-specific practices.
Okay, so the applicant's practices.
Correct. So
I guess maybe I misheard you, but just to clarify my own mind here, so purchasing local and hiring local, would that be something that you'd see generally in a joint development agreement between an applicant and local government?
I don't know.
Okay, you haven't seen that before.
No, I haven't seen that before.
Okay, that's fine. Just want to make sure. Okay, that's fine. So any questions? We have Clean Wisconsin questions.
No, Connor.
And Lauren Tom.
I do just have one question. We were talking about the conversion of agricultural land from crop-based growing to solar energy, and the soybeans and corn that were used for that. Are you aware, Mr. Loomis, that not every year corn is grown in the same field for 30 years straight?
Yes.
So when the analysis was done, was that taken into consideration, the crop rotation that's done in order to protect the health of the soil?
I don't believe we assumed anything in terms of the of crop rotation one way or another.
So it's not exactly accurate as to how farming is done in those fields then. It's just trying to take only corn for 30 years as its base instead of actual agricultural practices.
Yeah, so we took the solar lease versus it's a snapshot in time for corn and for soybeans. And so if it would be a mixture of corn and soybeans rotating throughout those fields. As the practice, the results would be somewhere between those two. So in other words, you could view the results as being 30 years of corn or 30 years of soybeans. And if there's a mixture of corn and soybeans, it would be somewhere between those two results.
Are you aware that other crops are used in rotations besides just corn and soybeans, that might not be an accurate description?
My understanding is that corn and soybeans would be more profitable and therefore would be the best kind of test case against the solar leases.
Okay, but you're not taking into account any other crops that would be produced in those fields during that 30 years for their regular crop rotation.
No, I just considered corn and soybeans.
Okay, then one final question I have, I guess. In the economic studies, there were figures on how much money would be generated from this project at the county level and how much money would be made, would stand to be used at the state level. In what time frame are those amounts? Is it for the whole life of the project, or is it just during construction? How are those figures calculated?
Those would be annual payments for the life of the project.
Maybe I didn't explain well enough. Not the credits that the county gets for the energy that's made. There were figures in there about how much revenue the state would be seeing potentially, and as well as Columbia County as a whole, based on these jobs coming in. Do you want me to find that?
Yeah, could you point
section?
me to where that is in my report or testimony?
I'm trying to find it here.
Your Honor, it's an appendix to the CPCN application, the report, rather than an
Oh,
exhibit.
yes, thank you.
Appendix R, I believe.
Yeah, you're right, thanks.
Yeah, so I'm looking, actually, I didn't make it any farther than page 1 in the executive summary, and I know there's more down farther, but it lists earnings, like it says over 12.7 million in new local earnings during construction, and then 579,000 in new long-term annually. So are we to expect those figures, like the annual figure that you stated, over the entire length of the project?
Sorry, I was pulling up the.
Oh, I'm sorry.
Or could you repeat which figures we're referring to?
The ones listed under earnings on that first page.
Yeah, so the first and the third bullet point, I'm sorry, the first and the second bullet point are referring to earnings that occurred during construction. So those will only last during the life of the construction. And then the third and fourth bullet point, reading over $579,000 in new local long-term earnings for Columbia County annually. So that would be during annually $579,000 annually for the life of the project.
Okay, and how how do you calculate those numbers? Is it just based on the amount of long-term jobs that are proposed for the project?
So it's based on inputs from Ursa Solar to look at what they plan on spending in terms of payroll, in terms of materials purchases, and in terms of services. Those are used as inputs into the model. And then the software that we use, InPlan, is specific to either Columbia County for that third bullet point, or the state of Wisconsin economic data for that fourth bullet point.
So just so I make sure I'm on the same page here, the 579,000 for the Columbia County amount that's listed there would be because of the 2 to 3 full-time jobs that Ursa is indicating in their application?
No, this would be associated with the, on that same page in my report, this would be associated with the 14.5 new local long-term jobs for Columbia County.
And
so those are earnings associated with those jobs.
And how do you come to that 14 point whatever amount when the applicant states there's 2 to 3 full-time jobs that they're looking at creating?
So that is explained later in my report. There are 3 different effects that I measure. One is the direct effect. In direct jobs would be those jobs that are employed directly employed by the applicant, by Ursa Solar. And then I also measure the indirect jobs. You could think of those as supply chain jobs. And finally, induced jobs, which are normal household purchases made in the community because people have earnings associated with those jobs to spend money on.
Okay, thank you.
All right, so any questions from commission staff?
No questions.
Okay, so when this Loomis, I did have one other question about the comparing the 2 different studies, one from High Noon and one from this case, and also just another. It shouldn't be very complicated, but I just noticed that the crop prices were I think they were fairly different between the 2 projects, and just curious, is that just in the nature of timing of the study when the study was done?
Yeah, that's going to be differences in timing. There have been some fluctuations in recent history on the price of corn and price of soybeans.
Yeah, it was. Yeah, I don't have the numbers in front of me, but it was a significant difference. So, okay, great. All right. So no other cross, any redirect?
No redirect from me, Your Honor.
Okay. Well, thanks very much. Appreciate your testimony.
Thank you.
Ursa Solar calls witness Michael Marus to the stand.
All right. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Mr. Marus, did you cause to be filed rebuttal testimony as well as 2 exhibits in this case?
Yes.
And if asked those same questions today, would you provide the same answers?
Yes.
Do you have any modifications to your testimony or exhibits?
No.
Is the testimony and are the exhibits you caused to be filed true and accurate to the best of your knowledge and understanding?
Yes.
Do you have an additional exhibit that you would like to introduce into the record today?
Yes.
Can you please describe
I would like to introduce exhibit Ursa Solar Marus 3 into the record.
Thank you. Please summarize this exhibit.
This is the Columbia County Tax Assessor's valuation of the property. located at N5749 County Road A in Cambria, Wisconsin, 53923.
Is this additional exhibit true and accurate to the best of your knowledge and understanding?
Yes,
Have you reviewed the surrebuttal testimony of intervener Lauren Ton?
yes.
What have you done to specifically analyze Ms. Ton's property?
I have reviewed the county assessor information. I have viewed Google Earth to learn about her property and the area property. I've inspected the exterior of her property in the area to consider possible impacts from the proposed solar panels. I have reviewed Zillow regarding historical information and reviewed general comparable data to consider a possible market range for her property. I have also reviewed drawings showing the distance from her residence to the proposed solar panels and considered the intervening trees and vegetation from her house and the proposed solar panels.
On page 7 of her surrebuttal testimony, Ms. Ton concludes that the market impact analysis you performed and provided as exhibit Ursa Solar Maroos 2 is not adequate to assess the property value impacts in the project area because many of the properties you analyze are near solar facilities smaller than the project. Do you agree with Ms. Ton's conclusion?
No. On page 72 of my report, exhibit Ursa Solar Maroos 2, there is an analysis of information from the Badger Hollow 300 megawatt solar farm in Iowa County, Wisconsin. In that same report at page 73, I considered information from the Two Creeks 150 megawatt solar farm in Manawak County, Wisconsin. Finally, on page 74 to 79 of that report, I analyzed the impact on property values of the North Star 100 megawatt solar farm in North Branch, Minnesota. My analysis has ample reference to and use of utility scale solar projects.
In arguing the project will impact local property values, Ms. Ton references on pages 7 and 8 of her surrebuttal testimony the list price of a property for sale at the address N5749 County Road A, Cambria, Wisconsin. Can you please address Ms. Ton's use of this property and her testimony, and whether it supports her position on the impact of the project on local property values?
A review of the only appraisal that is on public record for that property provided here as exhibit Ursa Solar Maroos 3.
Okay, I'm just going to interrupt for a second. Just want to know if there's any objections to the incorporation of Maroos 3 into the record. Okay, don't hear any. So, okay, go ahead. That's in the record.
Shows that it is the assessor's professional opinion that the property has a market value of $120,600. The property is listed for sale at $399,900, according to exhibit LT Tom 13. At pages 7 and 8 of Ms. Town's surrebuttal, she claims that the property described in exhibit Ursa Solar Maroos 3 is listed for $50,000 under its appraised value. However, Ms. Ton never provided an appraisal supporting the statement. Based on the only appraised value of $120,600, the property is actually listed for sale at $279,300 above the appraised value, or 3.3 times the appraised value as of April 11th, 2023. After I reviewed the features and size of the property, it appears, if anything, the apparent high asking price is the reason the property has not sold.
On page 7 of her surrebuttal testimony, Ms. Ton claims the conclusion in Lawrence Berkeley National Labs study on the property value impacts of solar farms, provided as exhibit LT Ton 7, are applicable to her property because it is valued similarly to the average value of the Minnesota properties evaluated in that study. Do you agree with Ms. Tan's analysis?
No, Ms. Tan only provides part of the factors considered in the study. And for that reason, I disagree with her analysis. The average value of proximate properties is one factor to consider. However, the Berkeley study was focused on small scale solar farms averaging 5 megawatts in generally suburban locations. These small projects have limited economic benefit to the taxing bodies and also participating property owners. The Berkeley study did not study large scale projects similar, such as the Ursa solar project, which is at 200 megawatts, which provides significant economic benefits to the taxing bodies, communities, and the participating property owners. The Berkeley authors acknowledge that the economic benefits have not been factored in their conclusions.
Has Ms. Tan's testimony in this proceeding changed your analysis on the property value impacts of this project?
No.
Does this conclude your Ursa rebuttal testimony?
Yes.
The witness is available for cross-examination.
All right, Clean Wisconsin,
No questions, Your Honor.
Lauren Tan.
I do have a few questions, yes.
Go ahead.
Mr. Maroos, isn't it fair to say that most county fair market value prices are not similar to what a sale price ends up being in a rural market?
You mean the assessor's opinion of value? Is that your question?
So the 120,000 figure that you have on your exhibit, the fair market value, isn't it safe to say that that number is usually quite a bit lower than what the sale price would be for a property in a rural market?
Just to be specific and not argumentative, for rural residential property, the assessor's opinion of value, in my experience, generally is less than the market value. But in this situation, the asking price is triple the assessor's opinion, and that is a radical difference.
Have you looked at any other properties in this specific area, the project area, that have sold recently, what they were appraised at the county and what they actually sold for?
Generally speaking, and the numbers indicated that the sale prices, that the market has been strong, and the sale prices have been higher than the assessor's opinion, but none that were 300 or 3.32 times higher.
So again, have you looked at anything in this area for a recent sale to compare what the fair market value price listed is compared to what the sale price of the home was?
I have, but I haven't done a specific study, and my general answer is the 3.32 times differential in this is significantly higher than any of the comps, but I haven't done a specific study.
Can I have just a moment, Your Honor? I'm trying to pull up a tax record to try to help clarify things, I guess.
Okay, off the record.
Okay, I don't know if I would have to enter this into evidence too then, or I guess I'm not sure how this would work, Your Honor.
Well, neither am I at this point. To be
Are we
honest
off?
with you.
Are we off the
Uh,
record still?
Yeah, let's stay off the
Okay.
record. So you have a particular land record that you found at the county treasurer's office, is that?
Yes.
Okay.
Hey, Your Honor,
Um,
if I may briefly, if Ms. Tan's going to be speaking to something that's not currently in the record, that might be appropriate for her own testimony, but to ask a question in cross-examination on something that's not in the record that we haven't looked at, I'm gonna have to object to that. That doesn't seem appropriate.
These are all public records.
Yeah, this is kind of this is an interesting situation procedurally. I mean, so on cross-examination, certainly fair to come up with documents to test the witness's assertions. And these are what I'm assuming is a public record. I mean, I think what I want to do just first is just to take a look at what you've found.
Sure.
In which I can do on my system here. So did you use the Ascent land records system? Is that what's what I'm
Yes.
looking at here? So I don't
Your
know.
Honor, one other note here,
Mhm.
and I recognize Ms. Tan's pro se and appreciate and have no objection generally to more flexibility because of that. But the ALJ scheduling order required the provision of documents to be used at the hearing 24 hours in advance, or by 1:30, I should say, the day before.
Yes.
And I bring that to your attention as well.
Yeah, and that may be where we are headed here, but I did want to. And I guess maybe it's my perception because I didn't get a chance to see that document until I didn't get a chance to see Marus 2 until just before the hearing, but that's not the case for everyone else. Well, so let's stay off the record. So do you have the address for that document?
Yeah. W 1787 Holnagel Road, HOLLNAGEL.
Okay, give me the name of that street again.
Holnagel, HOLLNAGEL.
Okay, so you said West 1787?
Yes.
Yeah, that's not coming up. Columbia County.
Yep.
Oh, maybe I have to choose this. No. Okay, so I have that document here. So I have here, it says estimated fair market value is 0. Is that what you see?
If you bring up the tax bill from the last year, the 2022 tax bill, it will show the fair market value on there. It's a better way to review it.
And do you have something to compare it to then, in terms of a sale?
Yep, down, if you go back to where you had seen the 0 figure for fair market value, in the sales history, it shows a sale that was just recorded in April.
And so for the property that we were talking about in Marus 2, the sale difference between the sale price and the asking price and the appraised value was 3 times bigger. Is that what we had determined?
3.32 times, Your Honor.
So I am hesitating to put this new document in the record because of our process requirements to allow the 24-hour period to, or at least the half a day to go by before we have although, hang on.
Well, can I maybe explain why I wanted to point this out, or?
Well, I think I think I understand that, but I think what we could maybe ask another question without the document, but I'm just curious, just to be sure, and I just want to double check refresh my memory about our processes for documents used to impeach should be shared. I don't know if that's actually that specific anymore in our rules. Maybe remembering an older version of that. Let me just take a peek at that.
Your Honor, while you're doing that, could I just briefly support our objection on this? Or is that better saved for another?
Yeah, I won't be paying attention, to be honest with you.
Okay.
I'm going to be looking at the computer, so probably better to save that. Yeah, so I'm just going to display our facilitating matters. This is kind of what we're our benchmark for standards here. And it is to allow everyone the opportunity to see documents ahead of time. So that page 4 of our audiovisual supplement indicates that documents to be used at the hearing shall be shared via email to parties no later than 1 day before the party hearing session. So that is important in terms of our process. So let me just hear what the applicant has to say about this.
Thank you, Your Honor. Just going to mention that basic due process principles govern, these proceedings when it comes to evidence. I know that we have lax evidentiary standards, but the opportunity to respond to something is a basic due process issue. And Ms. Tom bringing in exhibits that we haven't had a chance, Mr. Bruce hasn't had a chance to review at the last minute is an undue surprise and something that would, Mr. Bruce can't be expected to respond to in any kind of adequate way based on it being brought up at the last minute right before the during cross-examination. And if this was allowed in, theoretically any public document relevant to the proceeding could be brought in at the last minute and witness would be forced to answer on it. And so just for those reasons, I think it should be excluded from the objection should be sustained.
Can I speak to that as well,
Oh,
Judge?
I think we need to do that again. Sorry. We should get this on the record. It's my fault. Yes. Okay, so on the record, we're discussing the inclusion of a new document in the cross-examination of witness Marus. It's been pointed out that our facilitating matters audio visual supplement does require that documents used at the hearing and not previously offered be emailed to parties no later than 1 day before the session. And then so Attorney Peterson, can you just reiterate your objection to the use of the document at issue?
Sure, Your Honor. So our argument is that basic due process principles govern the evidentiary standards in these proceedings, even though there's lax evidentiary standards. And one of those due process principles is being able to respond to evidence that's presented. And Mr. Marus hasn't been given that opportunity here. It was this evidence and these exhibits were brought up during cross-examination in violation of the facilitating matters ordered in a contested case proceeding. And he can't be expected to respond to these questions in any kind of fair, reasonable way based on this last minute introduction. And so for those reasons, I think the objection should be sustained.
So any response from Orenton?
Yes, Your Honor. Had I anticipated I would have needed this during a cross-examination, I would have gladly included it, but it has come up through the testimony that he's given here today, Mr. Marus, and the answers to the questions that I've been asking him. So it wasn't, I'm not trying to pull a gotcha or anything. I'm just trying to offer a comparison.
And I'll just note that might be more appropriate in her direct testimony than on this cross-examination.
Well, so, okay, well, I should have taken that hint in the beginning. So witness Peterson, Attorney Peterson, does the applicant have an objection for the witness Tan introducing this information on supplemental testimony on the stand?
I have no objection to her discussing matters generally, but as far as the exhibits go, she can, I think it's appropriate for her to talk about this in her testimony on the stand, but will remain our objections to actually introducing the exhibits into evidence at this time.
Okay. So this does present an interesting issue, at least for me. So we did get, and according to the rules, the applicant did file this Maroos 3 exhibit on time yesterday before 1:30 p.m. I guess I guess the ultimate intention of the rule, the standard, is to prevent someone knowingly withholding a document prior to the hearing, where this rule becomes most useful, and to prevent the gotcha moment when it could be shared ahead of time. Also, the reason for this regulation in having it be in the Zoom hearing supplement is that it becomes difficult to actually share this document without people being together in the hearing room. So when we were together in person, we could bring up documents during questioning and pass them out amongst us and have parties review it at the time of the hearing. But having said that, of course, we're not there, and this is the rules. We haven't been in a situation before since going to Zoom hearings that we've had a offer of a countervailing document after the deadline being offered in response to something filed within the deadline, but pretty close to it. So we're forging new ground here. I think given the nature of this document and that it does and the relevance of it, according to the line of questioning here, something that I can bring up and put on the screen. It's certainly authenticated through Columbia County's website. So in that sense, there's at least those concerns are reduced in terms of authentication and foundation. It does directly address the issue at hand. It's a document that the witness should be familiar with. It's a similar document to Maroos 3, just a different property. So I think in consideration of all those factors and to complete the record, I'm going to admit this document. Well, let me present it first, and then I'll put it on the screen. But I think we'll need to mark it at least. So that's going to be Laurenton 16, and let me and it'll be something that Laurenton will need to file at the close of the hearing.
Your Honor, given the ruling you just made, we would ask for an opportunity to review the document at least, rather than have you pull it up page by page here. Maybe it's appropriate. I know we were talking about taking a break at this point.
Okay, that's
At
fair.
least give the witness an opportunity to look at the document.
Yep. Okay. Yeah, I don't think it's too much of a surprise, but yes, I think that makes sense. So do you have the well, I can still present it on the screen, and this way we're all on the same page here. So this is the property, the land record. It's at the initial page, and I think there'll be questions on the print tax bill, the 2022 tax bill. Well, let me ask, Lauren, did you want to just present the tax bill? I think that has
Well, the information is in two different areas
Okay,
there.
so
So the
the-
tax bill
that's
shows the fair
confusing.
market value and then that other page shows the sale price.
The sale price is,
Down at the bottom farther. Sale history.
sales history. Okay, yes. All right, so it'll be the sale history, the drop down from on the current page, and then the attached tax bill from 2022. Yeah, so take a look. Let's take a break. How long do you think we'll need to break for?
Yeah, I want to make sure I understand what we have. It's the tax bill for 2022 that you're going to make an exhibit.
Well, so let's just do this. So it'll be the initial page here that's on the screen. The tax bill for 2022. That's this page. And then back to the original page. It'll have to display the sales history, which is just, it's a drop down on the initial page.
And Your Honor, just to clarify, you're going to allow Ms. Tan to ask questions on cross-examination about this new exhibit to Mr. Marus?
Yes.
Okay.
Once he reviews it, yeah.
Yeah, so I would think a half hour from the look at this so we can get faster with it. I don't know if we're taking a break otherwise.
Well, this is a good time for a break. Okay. So let's do, can we do 1:15?
I need to make sure that he can access it. So can we ask him that?
Yeah, go ahead.
He's not physically with us, so.
Right.
I'm not sure I can. Could we briefly go through it and I can take notes on it so I make sure?
Okay.
Would that be possible?
Okay, let's go off the record at this point. So this is Columbia County. Columbia County.
Yeah, I'm familiar with what it is. I just want to see if the numbers match up with what I've seen on my own.
Okay.
And
All
I
right,
want to.
well, give me some direction. What do you need me to do?
Just scroll through the entire document.
Okay.
So maybe keep scrolling down, please.
Okay.
Keep going.
Your Honor, I'm sorry, I don't mean to. I mean, this is why this process is not working for the reasons you said. So if I would suggest that if Ms. Tan wants to cross-examine Mr. Marus on this, she creates a PDF of what she wants, she sends it out, and then we have a half hour after that to look at it and respond.
Sure, that's fine. Okay. Can you do that?
Yep.
Okay, so let's break until 1:15. And we'll come back and take care of this.
Yeah, I just want to make sure we have enough time to look at it, Your Honor. So I would ask for the break to be for a half hour after we all receive it, including yourself.
Okay, well, let's keep it at 1:15 and then see if we need more time, because I don't think it's going to be that long that we're going to need. So we'll check in at 1:15.
Thank you.
All right.
Hello?
Yes. Is there? Okay, so recess to 1:15. We'll meet back here at that time. Thanks. Okay, we got about another minute or so to check in.
Sorry if you're waiting for me. My timer didn't go off.
No, we're right on time.
Good.
So it looks like we have the primary people we need here. There we go. Okay, so it's 1:15. It's off the record. Can we just have an update as are people ready to proceed, or we need some more time?
Your Honor, we're ready, assuming that Mr. Marus is there. I see him. Thank you.
Yeah.
I do have a recommendation. This particular piece of property, as you can tell from the name on it, was bought by a trust that Lynn Wingers controls. I believe he can provide some testimony that's relevant to this issue. I would suggest we do that first, rather than having me call him after Mr. Marus finishes testifying, because I suspect I'm going to have to call Mr. Marus back after he hears what Mr. Wingers has to say about the property and why he bought it.
Okay, that's fine. I'll give some leeway with that. So, so let's see. So we did have the well, we do have a pending question from the witness from the party. I think, yeah, it may be more cumbersome, but I think let's have the questions from Ms. Tan first. And then we can do what we need to clean up any remaining issues about the property. So we're already kind of in the middle of cross, so maybe that's maybe just a better process. It may be more cumbersome, but just keep things lined up like they usually are. So we do have the exhibit that was marked as LT TON 16. So let's get on the record. Oh, sorry.
It's okay, go ahead.
To swallow. Okay. So LT TON 16 has been marked. So I think so I think I see what you're saying now. Attorney Callisto. So we can get why don't we get some foundation for this from the landowner who is a witness in the case. So I think that is probably the better way to go. So we can recall Lynn Wingers on the request of the applicant, and Attorney Callisto, you want to proceed with some questions. I just want to see where Lynn is on my screen here. Oh, you lose it. There you are. Yes, I was going to say, raise your right hand. Remember, you're still under oath. So yes, with the foundation questions.
Thank you, Your Honor. Mr. Wingers, did you or a trust that you are in charge of recently buy the property at W1781 Holnagle Road in Randolph?
Yes, W1787 Holnagle Road. Yes, I did just purchase that property.
1787. And I would just ask the exhibit is improperly marked on that, but thank you. 1787 Whole Nagel Road. And why did you buy that property?
I bought that property because my daughter and her husband and my 5 grandchildren wanted to move closer to home. And that property is contiguous, that land that I already own. So the grandchildren can run back and forth from their house to our house without going on the road. And it was very close and handy. That's why I purchased it.
And please describe the process about how you approached the then current landowner to buy the property.
I had heard through the grapevine that Richard Regnerus, the previous owner,
I'm sorry, Richard.
Regnerus, Regnerus,
Thank you.
that he wanted to sell the property. So I just drove in his driveway and talked to him. And he said, yeah, he was still thinking about it. So we came to an agreement and I purchased it.
And can you please describe the property generally as you understand it?
I believe it was in 2012 a tornado went through this area and it took out the old shed and the barn was damaged and some other damage happened. So back in 12, I think it was 12, the property was all remodeled, a new roof, new windows, new siding, a new deck, and a new shed was put up. Finished on half of the shed, completely concreted the whole shed. And so it was a pretty freshly spruced up property. And the house is, I believe it's 25 or 2,600 square feet when you count the full first floor, and half of the house has a second floor. So 5 bedrooms, 2 bathrooms, enough for my daughter and her husband and the 5 grandkids.
And as you understand it, the house was not otherwise listed for sale in any public manner at that point when you bought it, correct?
Correct. It was never listed with a realtor.
And did the fact that the property is contiguous with your property and is going to be occupied by your children and grandchildren have an impact on the price you paid for that property?
Yes.
In what way?
If it was not contiguous, I wouldn't have bought it.
No further questions from Mr. Wingers on this topic.
Yeah, I'm just curious if we can just have him authenticate what we see here on the screen. It's the Laurenton 16, and it's the Columbia County Ascent Land Record Suite that shows the owner of the property in question as Lindy Wingers Living Trust. So I just wanted to make sure that you recognize that document as being related to your property.
Yes.
Okay. All right. And I was just curious because the appraised value where is that now? Oh, it's on the tax sale portion. So if we drop down to the last page of the exhibit, it does show the property tax bill for 2022. The total estimated fair market value of $222,400. That was the fair market value from last year. And the purchase price for consideration paid for the sale this year was $435,000. Just curious, were you aware of the fair market value estimated at the time you made the purchase?
No, I really didn't even look at that.
Okay.
We just came to an agreement on a price and that was that.
Okay. And then just curious, the house right now that's on that property, was that damaged by the tornado? Wasn't quite clear for me.
It was damaged by the tornado.
Okay.
So it has been repaired and it's freshly remodeled.
freshly modeled. Okay, great, thanks. So in terms of the square footage, is that changed from 2022 to 2023, the remodeling, or is that reflected in the tax bill?
That should be reflected. Nothing has changed in the last couple of years.
Your Honor, I had one more question I failed to ask him. I think it's material.
All right, yeah, go ahead.
Mr. Wingers, in your pre-filed rebuttal testimony, can we please go to that?
Yes, hang on. Let's go off the record for a second. It may take me a minute to.
Mr. Wingers, I'm going to ask you to go to your rebuttal testimony, page 5.
Are you back on?
Just let me get to the page in a moment.
Okay.
Okay, I think we're there, page 5. Yeah. Go ahead, on the record.
Thank you. Mr. Wingers, we're at your rebuttal testimony, page 5. Can you please read the sentence that begins with the word I on page 1, line 1 of page 5 of your rebuttal? And it's up there on the screen. Sorry, go ahead.
I hunt here in Columbia County,
No,
and I
I'm
consider
sorry.
myself.
I'm going to stop you. Line 1, please. I just bought.
Okay, up there.
You
I
said
just
it.
bought another property for my children and grandchildren to live in, neighboring the Tons. That will be within 100 feet of the panels. The visual of the project is a sign of progress and clean energy for future generations.
Mr. Wingers, is that property that you just described in your rebuttal testimony the same one that we're talking about here?
Yes.
No further questions.
Okay, great, thanks. That's good clarification. So I just wanted to be clear, as far as you know, the improvements that were made, the repairs that were made to the property after the tornado would have occurred before the property tax bill for 2022.
Yes.
Okay, all right, that's fine.
Am I allowed to ask a question, Your Honor?
Yes, we're gonna get to you just a second. Sorry about that.
That's okay.
Yes, let's have you ask questions of this witness, and then we'll go back to your questions with witness Marose. So go ahead.
Thank you. Mr. Wingers, how are your children and grandchildren going to be able to get to you without using a road once the solar panels are installed and fenced around that property?
There will be a path outside of the fence to get all the way to my house. No problem.
And where is that shown on the applicant's maps?
Well, we have
Your
to
Honor,
pull
she
up-
can point him to a map and we're happy to walk him through that.
I'm looking at the land cover map, figure 4.1.7.4.
Well, I don't have the map in front of me, but if
Yeah.
you go to the east of the house.
Len, just wait, we're going to pull the map up on the
Let's
screen.
get off the record and I'll get that map up on the screen.
We're going to pull it on the screen. Just wait a second.
Right here. There we go. Okay, so land cover map, what was the figure number again?
4.1.7.4.
Pretty high level here. So let's see, I got the right one. It's like 4174. Will this map help us? Because it's pretty high level. I don't know. Is that something? Is this going to be useful?
Well, I could point it out, but I
Lynn,
don't.
let her ask a question, please.
Well,
I already asked a question.
we're off the record. So I just curious if we can, I mean, can we use, is this going to be useful or not? Just someone let me know. Where's the location that we're trying to go to exactly? So adjacent to the
So
John
array
property?
9
Yeah.
is there, and then you see 9A and 9B. The portion that's not in any color or show any arrays is the house that we're referring to.
That's the new property.
The
Or is it
property he
both?
just purchased, yes.
Okay, and it's supposed to be adjacent to the current, property that they already owned? Is that up? Okay, so we'll just need to get some direction from witness Winger here and Wingers, if you don't mind. So let's orient ourselves here so we can get it back on the record. Just hoping to orient us with the map here. So we're looking at the applicant's figure from its application figure 4174. And what we have on the screen here is zooming into that property, that area of array 9, 9A and 9B. So it looks like there's one property that's sort of carved out of the array 9 area. There's also a property just to the north of array 9B. So I'm just curious if you can orient us, witness Wingers, as to where your properties are located.
The area in black is a new property that I just purchased. 9A and B, all the colored stuff is also my property.
And then your house, where you live, is that just north of 9B or is it another location?
South.
South.
We'd have to zoom out a little bit.
Okay, that's helpful. Okay. So.
And now if you could scroll up a little bit. The other way, scroll down.
Oh, sorry. Great.
Okay.
So you're
on the very bottom, you see the buildings on the very bottom where 146 makes that big curve.
Oh, yes. Down. Okay.
That's where I live, right there.
So just north of where 146 turns to the east.
Yes.
So directly below array 9. Okay, got it.
Correct. Now, if you scroll back the other way a little bit, the fence for the solar project is going to leave room next to the highway. If the fence isn't going to be right on the road, there'll be a setback. They could come on that setback area and get into this bigger field and come right to my house.
So they'd be using the right of way of the road is what you're saying.
No.
Then please explain. I guess I don't understand.
Okay, we just can't be talking over each other. Okay. Yeah, if you could direct us from the new property, where would they start that trip across the array area?
There's a driveway from the new property that heads straight north to Honagle Road. Now, before they would get to the road, they could head west next to the fence, and then they would head southwest along that wetland area next to the fence, almost to 146, and then they would head south and get to that open field and then come to my house.
So they'd still be traveling along 146 in the right of way or the area that's left over after the fence goes in. Is that what you're saying?
the area between the right of way and the fence. That's what I'm saying.
Okay.
All right. Any other questions? Ms. Tan, anything else? No.
I don't know.
Okay, great. So anyone else have questions on this topic? Clean or staff? No.
No questions from PSC.
All right, so we need to ask for any redirect on those questions from the
No, Your Honor.
no? Okay, so let's recall witness Marus. And we can start the questions we were intending this to complete. And it's always fun. You never know what we're gonna encounter on these hearings. So I'm glad we pushed through this. So we have the Lauren Tan Exhibit 16 in front of us. And Ms. Tan, you had some questions for witness Marus, and we see him here. There you are. Yeah, just gotta wave enough and I'll see. Okay, so remember you're under oath.
I understand, Your Honor.
Okay, go ahead, Ms. Tan. You need to unmute.
Sorry about that. So taking a look at the fair market value for this particular property, the W1787 Holnagle Road, what is that shown as?
$222,400.
And according to the Columbia County website, what did the house actually sell for?
$435,000 or 1.96 times the assessor's opinion of value.
And would you say that just looking at, I know you can't do a very good comparison since we don't have all the figures for the house that we're referring to on Holnagle Road, but are the lot sizes fairly comparable?
The Holnagle Road lot is 6.4, so it's about 30% larger.
I'm sorry, what are we comparing? Which lots?
You're well, I think we're comparing it to the Cambria
Yes.
property that's on the market for $399,000, which has 5 acres. This parcel has 6.46 acres. So this parcel, the new comp, is about a 30% larger lot size.
And according to the exhibit that I had put into the record previously with my rebuttal, the house, the Cambria house, let's call it, was very recently remodeled. Is that correct?
Yes.
Okay, so these houses, you could say for this type of area where there are not a whole lot of sales to be comparable to, that these two properties are something that we would compare when looking at appraisals.
Not necessarily, because this property, this new sale, this about 2,600 square feet. The Cambria one is 1,600. You can make the comparison, but again, it's almost a 50% larger house. It's 5 bedrooms compared to 3 bedrooms. And it's got a large outbuilding that's half finished into an office. So you could make comparisons, but they would be significant comparisons.
Enough so that the price difference would be that substantially different from $435,000 for the Holnagle property to what you were saying was $120 for the fair market value of the Cambria property?
You're comparing apples and oranges, because if you're comparing the market value from the assessor, and that's the apples comparison, you're talking, and again, I don't want to confuse the numbers. I believe it's 222,400. Your Honor, do you mind if I use a calculator?
No, that's
okay. So if we take the $222,400 that the assessor has put on the Holnagle property, divided by the assessor's opinion of the Cambria property, which is, I think, 120,600. The differential is 85%. So just in the assessor's opinion of value, if you did that comparison. So, or if you divided the 120 by the, again, I'm going to come up with general numbers. I think it's 220. It's about 55% the Cambria as far as the percentage of market value. So it would indicate that the assessor, in his opinion, thinks not quite double, but feels that the Holnagle property is significantly superior to the Cambria property. And if it's sold, the Cambria property, I mean, the Holnagle property sold for $435,000. And if you take that 55%, just the ratio, it would indicate a market value of $239,500. The property's on the market for $399,000 and hasn't sold. And my point in the Sir rebuttal that the indicator probable reason that it hasn't sold is the price is too high.
So I'm trying to figure out the best way to phrase this. Using the fair market value assessment that the county has on the Cambria house, is that typical for a home that is newly remodeled on 5 acres?
As I had stated earlier, in my opinion, the assessor's opinion of market value was low for the Cambria house, just as the assessor, but the assessor's opinion for this new comparable was low, but the factors were significantly different.
So when the realtor lists that the house, the Cambria house is listed for 50,000 under the appraised value, what takeaways should we have from that? If, I mean, they're already indicating that they are taking a hit for the sale price that's listed.
Well, I think just as we did the investigation here, we have to understand more in the property you brought up as a comp, you know, based again on the assessor's indication, could be worth significantly more, potentially doubling more. I think that's aggressive. But if that's sold for $435 and just a general comparison, it might indicate that the Cambria house, you know, may be worth somewhere in the $250,000 to $300,000 range. But I haven't done an appraisal. I'm just using the numbers, but indicates again that the properties seems to be dramatically overpriced, and that's the reason it hasn't sold.
I guess we'll agree to disagree on that. That's all I have for questions, Your Honor.
Okay, that's good. Any other cross for this witness? No, all right, redirect.
No questions on redirect, Your Honor.
All right. Okay, so thanks very much. You're excused.
Thank you, Your Honor.
And that's our applicant witnesses. So are you ready to move on to Clean Wisconsin?
We are, Your Honor.
Okay, great. Okay, I see Paul Mathewson's there. So let me swear you in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record.
My name is Paul Mathewson.
And Dr. Mathewson, are you the same Paul Mathewson that prepared and caused to be filed direct rebuttal and surrebuttal testimony and associated exhibits in this docket?
I am.
And to the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes.
Do you have any corrections or changes to make to your testimony at this time?
No.
Dr. Mathewson, have you reviewed, excuse me, have you reviewed intervener Lauren Tahn's surrebuttal testimony?
Yes, I have.
In your opinion as a doctor of zoology, do you agree with Mrs. Tone's assertions on page 3 of her surrebuttal that animals larger than 6 inches tall will be unable to access the project site through the applicant's proposed fence.
No, I would disagree with that characterization.
Can you elaborate on the access the 6-inch gap will provide for animals?
Yeah, so animals are well known for the ability to pass through small openings. For example, coyotes are known to pass through openings as small as 6 inches. Adult white-tailed deer are known to pass through openings as small as 7.5 inches. So, I think based on that, I think it's fair to expect that animals up to the size of a coyote will be able to pass through the proposed fencing. And so relevant to this project, that includes nearly all wild land animals commonly found in the area, like turtles, other reptiles, rodents, rabbits, possums, skunk, raccoon, and fox. I would suspect that coyote will largely be deterred, but motivated ones could get through based on the scientific knowledge that they have been able to pass through openings that small in the past. But larger animals like deer, any possible bears or stray wolves that may come down, those will be excluded. But I think most common land animals, wild animals, will be able to pass through the proposed fencing just based on that understanding.
Thank you. And does this conclude your sir rebuttal testimony?
Yes, it does.
Thank you, Dr. Matheson. Your Honor, the witness is available for cross.
Okay, any cross? We'll start with the applicant.
No, Your Honor.
And Lauren Tan.
No, thank you.
Okay, so we have renew here. No, commission staff.
No, Your Honor.
Okay, thanks very much. You're excused.
All right, thank you.
We have Lauren Tan next. All right, swear you in, raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay. So Lauren Tan, did you file revised direct, rebuttal, surrebuttal, and 15 exhibits? And we just marked our 16th exhibit. Or is that correct?
Yes.
And are the filings that you've made complete and correct to the best of your knowledge?
Yes.
Okay. So we'll just need to have that 16th exhibit filed by the deadline. Otherwise, did you have anything to add from what you've heard here today?
I do not.
Okay. Any questions for witness Tan?
No, Your Honor.
Okay. Clean Wisconsin
No, Your Honor.
and staff.
No, Your Honor.
Okay. All right. Thanks very much. You're excused. Move on to commission staff.
Right. The commission would like to call Andrew Kraft.
Okay. There you are. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, let's go ahead.
Please state your name for the record.
Andrew Kraft,
What is your position at the Public Service Commission of Wisconsin?
environmental analyst.
Did you file or cause to be filed direct testimony in this docket?
Yes, I did.
Did you also file or cause to be filed an exhibit marked PSC-EA?
Yes.
Are the statements and representations in the testimony and exhibit you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
No.
Your Honor, the witness is available for cross-examination.
Any questions from the applicant?
No, Your Honor.
And Clean Wisconsin,
No, Your Honor.
Lauren Tan?
No, Your Honor.
No, that's it. Okay. Thanks very much, then. You're excused.
The commission would like to call Jeff Pitsymbol.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. And your volume is a little low, but I think we'll probably be okay. All right.
Okay.
Better. Okay. Well, let's move on. Go ahead with the introduction.
Please state your name for the record.
Jeffrey Kitzenbull.
What is your position at the Public Service Commission of Wisconsin?
I am an engineer in the Division of Energy Regulation and Analysis.
And did you file or cause to be filed direct testimony in this docket?
Yes, I did.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
Yes. I would like to offer alternative wording for the order condition related to stray voltage testing requirement into the record for the commission to consider in this docket. I am aware that in a recent solar CPCN docket, the commission approved alternative wording relating to its stray voltage testing requirement. The wording of the stray voltage testing order condition approved in docket 9815-CE-100 is as follows. The applicant shall work with the applicable distribution utility to make available stray voltage testing at each agricultural confined animal operation within 1/2 mile of the project facilities before any solar energy system construction activity that may interfere with the testing commences and after the project is energized. The applicant shall work with the distribution utility and farm owner to rectify any identified stray voltage problem arising from the construction or operation of the project in compliance with the commission's stray voltage protocol. Prior to testing, the applicant shall work with the applicable distribution utility and commission staff to determine where and how it will conduct the stray voltage measurements. And that's all I have to offer in addition.
Okay, is the witness available for cross?
Just had one question for the witness.
Go ahead.
Mr. Kitsimble, you're offering this alternate order condition just simply as another alternative for the commission to consider, and the order conditions you offered in your direct testimony still stand, correct?
That is correct. It's just an alternative, not a replacement.
Thank you. Your Honor, the witness is available for cross-examination.
Any questions from the applicant?
Just briefly, just for clarification, Mr. Kitzenbowl, can we turn to your direct page 8, please? I just want to understand better the alternative you've just proposed and how it's different from what you proposed on page 8 as an order point on stray voltage. Thank you. That's it, Your Honor. So just, you don't have to walk through this order point again. Can you just describe narratively what the differences are between what you just proposed and what you had in your pre-filed testimony?
I believe, let me pull that up. I believe rather than it specifically, one of the things that I noted is that rather than specifically list things like metal or conductive materials into the ground, the wording that was recently authorized by the commission basically says construction activity that may interfere with the testing commences. So one appears to be a little more, in my opinion, a little more maybe prescriptive, saying exactly, and the alternative language appears to would or potentially include more things that may interfere. But that's one difference that I see. Other than that, I don't notice any right at the moment, although I may be missing something.
Okay, and just so I understand your view on that first part, the language you just proposed probably provides more flexibility to the developer or less?
I guess I could see it being either. If something is prescriptive in the one, but yet the applicant determines and can, I guess, when they confer with commission staff, as it indicates on the bottom, can show that a certain thing would not interfere with testing, then I guess that it could be to the benefit of the applicant. If there are things that may interfere that are not set out specifically in the original language, it may not be. So it appears it could be either one depending on the specific situation, in my opinion, but that may be a legal distinction that as an engineer, I may not be aware of.
Thank you. No further questions.
All right,
I
how
had-
about
Oh, sorry.
Wisconsin?
Questions, Your Honor?
Okay, and Lauren Tom?
Sorry, no questions.
Okay, great. Any redirect from staff?
Just one more question. And Mr. Kitsimbel, is another difference in the alternate order condition that you proposed related to the, I guess, 1/2 mile language? I believe your direct testimony states 1/2 mile of the project area. And then the alternate condition states 1/2 mile of the project facilities. Is that accurate?
I believe that is correct. Yes, that is another difference. Thank you.
No further questions.
All right, great. All right, thanks very much. You're excused.
The commission would like to call Jury Rademacher.
Yep, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
Okay, please state your name for the record.
Jury Rademacher.
What is your position at the Wisconsin DNR?
I am a water management specialist within the Department of Natural Resources Office of Energy.
Did you file or cause to be filed direct and surrebuttal testimony in this docket?
Yes.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
No.
Your Honor, the witness is available for cross-examination.
Okay, applicant, any questions?
No, Your Honor.
Clean Wisconsin
No, Your Honor.
and Lauren Tom?
I have one question, Your Honor.
Okay.
Has the DNR been able to do any studies near industrial scale solar facilities and what concerns or improvements they've made to the area, the wetlands and water areas around them?
I am not aware of any studies that the DNR has done.
Are any planned?
Not that I'm aware of.
Okay, thank you.
All right. Any redirect?
No, Your Honor.
Okay, thanks very much. You're excused.
The commission would like to call Stacy Rowe.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay.
Please state your name for the record.
Stacy Rowe.
And what is your position at the Wisconsin Department of Natural Resources?
I am an endangered resources utility and transportation liaison reviewing projects for rare and non-game species impacts.
And did you file or cause to be filed direct testimony in this docket?
Yes, I did.
Are the statements and representations in your testimony you filed in this case true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
Questions from the applicant?
No, Your Honor.
Clean Wisconsin,
No, Your Honor.
Lauren Tom?
I do have a couple questions.
Okay.
Ms. Rowe, has your department at the DNR been able to do any studies on the effects that large scale solar has on endangered resources?
On endangered resources, no, the department has not.
Are there any plans to?
There are potential plans, but there is nothing solidified at this time.
Okay, thank you.
Okay, any redirect?
No, Your Honor.
Okay, thanks very much. You're excused.
Thank you.
The commission would like to call Samantha Whitens.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Need to unmute.
Sorry, yes, I do.
Okay, perfect. Thanks.
Please state your name for the record.
Samantha Whitens.
What is your position at the Wisconsin Department of Natural Resources?
I am a water resources engineer in DNR's Office of Energy.
And did you file or cause to be filed direct and rebuttal testimony in this docket?
Yes, I did.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
Questions from the applicant?
No, Your Honor.
Cleveland, Wisconsin.
No, Your Honor.
Lauren Ton.
Yes, Your Honor. Has your department been able to do any studies on large-scale solar effects for your department? Have you been able to do that?
No, not that I'm aware of.
Are there any plans to?
Not that I'm aware of.
Thank you.
Okay, redirect.
No, Your Honor.
All right, thanks very much. You're excused. That's all of our witnesses. And anything else we need to address before we adjourn? No, all right, we'll expect your refiling, the corrections and the new exhibits by the deadline. Otherwise, look forward to reading briefs and the process going forward. So, I did want to mention embarrassing little detail here. So I just have on the screen the results of the an IRF search for this docket, and you'll see that there's a public comment exhibit filed in this docket by me. That's actually the public comment exhibit for a different case. I misfiled that. So if you see that on IRF, be aware. We most likely will just make that an unacceptable filing, so you won't be able to access this link through this docket. And public comment exhibit in this docket will be filed after the public comment here, after the public comment deadline is over and we've received all the comments, and hopefully there'll be the comments in the correct docket. So just wanted to note that for everyone who's paying attention here. So, all right, so that's it. Thanks very much, everybody. We're adjourned.